Good morning, good morning, good morning, everybody. Happy Friday. Welcome to Twisted Tragedies, where we follow all the twists and turns. I am your host, Elise. And wowza, we got a Friday incoming Friday. So I just wanted to tell everybody Kevin is home. We did a little stream last night. I would like people to still say a couple of prayers for Kevin. I would very much appreciate that. And I know Kevin would too. His fight is not anywhere near over. So let's definitely keep saying those prayers for Kev. We want him to fight this and get better for sure.
Hey, what's up?
Hey.
Oh,
What'd you think of yesterday?
That guy, I don't know what he was thinking to show the stomach contents to the jury as a picture.
I called it though. Did I not? I knew it made one of them sick. I freaking knew it.
Like, that doesn't even make sense. That doesn't even make sense at all why you would do that. That guy there's something wrong with Mr. Alessi. Because, like, that doesn't make sense. You show the wounds
for a reason.
Yeah, you show the wounds, you show like that, but you show in the stomach contents. Like, what is your point in that line of questioning?
His point was she didn't call the Wishnitsky, she didn't call it that. She called it ulcers. So, like, it's the same thing, but, like, he wanted to play semantics with words because he doesn't know what he's talking about. So that's half the problem. He's not a medical professional. He has no idea what he's talking about.
He's an environmental attorney or something like that,
yes.
I think. And
I do always call it ahead of time. Like, seriously, like, my batting average is pretty damn good, I think.
And the fact is like, I think Hank did a good job because last time this woman was a disaster last trial. And this time it was a lot more clarified on cause of death and matter of, and stuff like that. And I think that it was a lot more clarified. And I just think Alessi he tries playing these word games by forcing people to go with his definitions. And he goes on and on and on. It doesn't just get to the point. Like, if you compare the lacrosse from last trial to this one, it's 9 day. It was actually
last year. She said basically anything could have happened, including aliens, and you know what I'm saying? Like, literally anything, anything could have happened.
Yeah, the cross last year was actually very good for the defense. This year he lost the jury. He literally made one of the juries sick from it. And then they're like, then you got people shocked that the family doesn't want to sit through detailing how their beloved relative was, autopsied. I mean, I think a lot of people would not want to sit through that type of behavior.
Well, I mean, even JMS points out, and then he showed somebody else's random person's stomach. Like, was that necessary, sir? Like, and then it was confirmed that the juror vomited because of the photo. Like,
that to me,
you're alienating his face.
You're alienating their jury. Sorry, early in the morning, and it just doesn't make sense what he was doing. His questioning was too long. Like, all you really need to do is just get the lady to admit, hey, you can't really
figure out what it was.
Figure out if it was a car or was he left out or he was beat up. You can't really, and you just go into like there was no damage on the legs too much. It was just only the small bruise. But like instead, he just draws it out and just doesn't really focus on the points you need to focus as a defense attorney.
And now, then Hank hammers in the fact that, like, you didn't have this information, and this information, but you also did have this information, and you still ruled it undetermined. Like,
yeah. And the problem is like they keep on saying there's no bruises on that. It's like, yeah, because they're comparing to the being hit from the front of the car to being hit in the back of the car.
And not being clipped by hit front on in the back instead of being clipped by the side of the vehicle.
Yeah. And I just think like a lot of people, it's just word semantics. But to me, it's like the worst thing is that the bruise that he has on his leg matches her statement that she has made on national TV, where she stated that she believed, like when she backed up, she saw that she tagged him in the knee, and it's exactly the bruise location. And that's what, like, I think Mr. Brent, like Hank Brennan,
it's also exactly the height of a person, John's height, where the knee would be where the bumper was. Like, literally the exact place.
So my guess is that she probably hit him and he rolled through the air a little bit because it was 24 miles an hour and landed on the back of his head. And pretty much that's all she wrote.
Pretty much.
And she didn't decide to do anything and just drove off because she saw that she hit him. Because the reason why she saw she hit him was because she saw on her inside her car that shows that like backing up.
Well, so, also, like, did you catch on to this Lucas machine conspiracy?
What's the Lucas machine conspiracy?
That's a machine that breathes for you, right? And it's the one where Alessi was basically saying, like, well, could the Lucas machine have caused the Wisniewski? And it's like, yeah, it could have, but not with the other things that also say that it was hypothermia.
Yeah, the problem is like, in the end of the day, the original reason why a lot of people believe John was beat up was because of the two black eyes.
Raccoon eyes.
The raccoon eyes. And a lot of people didn't understand the concept of raccoon eyes and how he had a traumatic brain injury that caused swelling and bleeding, kind of like the swelling of his eyes. And the fact is that the medical exam, you know what I mean? Like, you need to, there's no issue, there's no evidence of a beating. Like, that's the problem. And how Hank kind of questioned and said, like, the ribs could be broken based upon, CPR. And that's actually a true statement, like a fracture, whatever.
Yes.
So I think, like, honestly, she was horrible last trial.
Better this time.
But still way better. Not the greatest.
Way better.
I did like the fact that she outlined that there wasn't any real depth, that she doesn't record it unless there's, she sees depth. And the thing is, if you're bitten by a dog, you're going to have puncture wounds in your arm.
Yes.
Some sort of depth would occur. So that showed that there is no depth. So
there was no depth. She called them scrapes.
Yeah. So the fact is that, if you still believe that the dog has lion-like claws or somehow bites without any
its teeth are this far apart.
Yeah, it's just not possible. It's not possible. So what did you think of the bombshell of the fact that they're fighting not to let the text stream data in where, like, the last moment of impact, I believe, right?
So no, their argument is this. Their argument is that Hank's expert went after some more information that their expert sort of zoned in on recently again. And so their expert, the Commonwealth's expert, went and looked at it, and they went through the data, and he's still going through it. But what he's trying to say is that the defense expert didn't calculate it properly because things like your car or your phone can have different clocks or different seconds.
Yeah, obviously.
Right. So, like, there could be a 7-second difference between
your phone has 3 different clocks.
Right. And your car clock. You know what I'm saying?
So, I mean, I think, like, they're going to try, like, to play semantics and try to, like,
they are. I don't think it's going to be successful for the defense. And I know we don't really like this judge because she does all sorts of crazy shit. But here's the thing. Is she allowed, even after Rule 14 violations, ARCA to bring their stuff in last minute during a trial? So I really don't think that she could unallow this. You know what I'm saying?
I think what Hank is asking for is actually, the best thing you could probably allow. Basically, allow the guy to come back and to rebut the testimony.
Yeah.
And I think that doesn't, basically leaving it open, because at the end of the day, you dropped about a couple of gigabytes of data on a person in the middle of a trial. And I'm sorry, that's if that was done to the defense, that would be a mistrial.
Is that Terry running?
Oh, absolutely.
So
these idiots get arrested yet, or what?
Which idiots? You got to
be
precise.
In the buffer zone.
I don't know. I mean, there's a lot of stupid people. You got to be precise with the stupid people.
The stupid people
you got
who
TV
listen to the Stewart Turtle.
You got TV showing pictures of underage kids, not realizing that they're witnesses to a case, and his bail might be.
He knows they're witnesses to a case. He knows.
Yeah, but you know what I mean. Like, I'm playing semantics. But,
I know.
But the fact is like, this is just, there are a lot of stupid people.
That made me
I'm
so
talking
angry.
about. But I'm talking about I'm talking about the text stream data that shows, like, the moment of impact.
Yeah.
Coincides with Mr. Whiffen's calculations on when the phone stopped moving. Even if it's a little bit off here and there, just a few seconds here. Yeah, but the fact is, like, nothing's perfect with the clock. You have 3 different
Mm-mm.
times on the fucking
And
phone.
that's Hank's point is like, there's 3 different clocks you're dealing with here. So even if this clock and this clock don't line up to 11:37:02, this could say 11:37:02 and this could say 11:37:09, and it's still the same exact time because the clocks are different.
Yeah, but you
See?
know what? That's where the jury will probably, once the experts come in and explain it, that's where the jury has to make a determination on the evidence and which evidence is more important. Now, personally, I think the problem is with ACA is that they could come out with very good testimony, but they've been prejudiced. They not prejudiced. They've been like basically,
They're
um,
biased.
they're very biased, and Hank can question them based upon their biases, and
And
that's
Wolf
going to
is
be
very elusive. It makes him look guilty the way he
and
answers questions.
and could probably ask him like about like, oh well, did you not lie on the stand last time you were around
He
here?
can.
What?
Did you
Yeah, you know
use
what I mean.
Signal?
Yeah, did you use Signal? Like, you know what I mean? Like things like that's gonna remove like if
Yeah.
this was just a neutral group of people, they would have been a lot better
I
in the
think it was
situation.
a grave miscalculation by the defense to hire Arca for the second time
Yeah,
around.
I just don't think it was a smart move. And then to place, to make them do new data and all that stuff. I think it's a very bad situation for that, but we don't know. Maybe it will work out for them. Maybe the jury will like Mr. Crash Daddy, who crashed on the stand a couple of times, let's just say.
I don't
And
think so. Trevor makes a
yeah,
good point here. What do you think about this? Alessi, he's talking about Alessi, like the lawyer pretending to be an expert in literally every subject, like Alessi does. It's off-putting to people unless you're in a cult and
yeah,
think
they
wrong.
call it. There's a word for that. They call him a know-it-all, and people
Yeah,
don't like know-it-alls.
here comes the
So
cult. I see cultists.
yeah. Sometimes people call me a know-it-all, and they don't like me. It's
Me
as
too.
simple as that. So the fact is like, I think Alessi is, for a medical examiner like that, you need someone like Jackson Cross to get to the meat and potatoes of your defense and then basically come out of it. But allowing Alessi to do these witnesses to me is just, when you have the father of the, alleged killer falling asleep in the stand, it's not a good sign. It's not a good sign.
No, oh my God, he was literally sleeping.
Yeah.
Like,
I was reading comments on lower tuber channels last night, and people were saying Alessi is brilliant and they could listen to him all day. Well, sometimes people lie in comics, or maybe they're trolling. Because I could not listen to the guy all day. The guy is terrible.
you can
Like if
barely
he was,
listen to him for 5 minutes without your brain automatically tuning out. You feel it tuning out, and you're like, "Oh shit, I gotta."
if this guy was for the prosecution, I'd be like, Jesus Christ, this lady's getting off 100% because this
Right.
guy is terrible. Like he is just too much of like, he doesn't get into the meat and potatoes, and he doesn't know how to read the fucking room. You don't
No.
show the stomach contents of the victim when there doesn't relate to the case at all. And it's
Did you
just
just see that? The
what?
trooper walked, like, see the person in the, I think that's Chrissy Mello, but in the pink shirt with
Mhm.
the, yeah, that's Chrissy Mello because she's got the camera. The trooper walked right alongside her down to where she was. You still can't be standing and hanging in the buffer zone, dude. The order was clear by the judge. She did not change where, like, the length of the buffer zone.
Yeah, but I just think I think, oh, is that the juror, the
Where? No,
ex-juror?
that's not her. No, I
Okay,
don't
who's
think
that?
so. Doesn't look like her.
Okay.
Victoria George, yeah, the one that
Yeah.
hasn't shown up since the first week of trial.
Yeah. Tom CPU and Boston Mike mocking Grant being Spectrum. Well, I mean, I'd rather be on the spectrum than be what Tom CPU is alleged to be. So I'm just, and his weird ass behavior.
Grant is autistic, and
Yeah, I
okay,
mean,
great, like
yeah,
so my
I'm just
nephew's
saying,
autistic.
Tom CPU said some really fucked up and weird things that
Yeah,
honestly, I'd rather be on the spectrum, autism, whatever, than be whatever Tom CPU is. So I'm just saying.
facts. I mean, a lot of the things these people say are like literally
Yeah,
ridiculous to me. Like,
it's
not
it's
for nothing, but
disgusting.
if we're going after people's, just they do it to me all the time. They're like, why don't you get a real job? I'm like, yeah, my real job is the caretaker of my children, and I'm
Yeah,
also
that's a job.
disabled. I'm disabled. I have CPTSD and not myocarditis of the heart. I could keep going down the list of things that are wrong with me, unfortunately. But I'm disabled. So I'm home with my children and dealing with a lot of severe health issues on top of my kids' severe health issues. It's not easy, dude. I would gladly still be working at the prison if I could. Who wants to pay that 40 grand in childcare? You let me know. Like,
yeah. So what do you think of the fact that, I mean, like, why do you think law tubers is just like, because like to me, like I'm listening to the case, right? And so far we have Karen's own incriminating words. We have literally data from the phone showing the route and exact moment he stopped moving. We don't have any we have no witnesses that say that he went in the house. We have no data that shows he went in the house. We have really nothing that shows that anything like that. And yet they're sitting here and they're acting like they're doing such a fantastic job of like.
Is that not crazy to you,
I feel like because like when I watched the Lilani Simon case, they literally used that cell phone data to get in her own incriminating words to get her to go to jail. And to me, it's like this woman not only said incriminating words, but you have her data, you have the fact that she has admitted that she knew what she was looking for, and you have her, basically even stating like I hit him basically in front of the niece as well. So you have like a situation where you have not only 1, 2, 3, 4 witnesses stating that she has stated this multiple times, and yet these people and also people are like sitting there like, well, how could a hair be stuck to a car? I'm like, yeah, just Google it.
Go in the shower, put a hair there, and see how that works.
Well, you Google it, and it says yes, a hair can stick to a car if it's wet and it gets to 32 degrees. What was the temperature that night?
18.
I guarantee 18. So the fact is that it got wet and it got frozen. And you have to realize that it only started snowing at the time when John was hit.
Also, there could have been a couple more hairs, but only one remained.
Yeah. And that's the thing. And they can't explain it. So they're trying to say, like, for some weird theory, they're thinking that somehow proctors with the tweezers are just putting one tiny hair on the back of a car. That doesn't make sense at all.
Not only does it not make sense, but when.
Yeah, but I feel like I'm listening to two separate trials whenever I listen to a law tuber, because I sit there, I'm like, I think you guys are not quite understanding the perspective of a juror. I think they're too much into like, I don't know, Karen Reed's camp of thinking or something like that. But in the end of the day, Occam's razor is what I usually go by.
Easiest answer.
Which is more likely than not. Did the lady basically got in a drunken rage, back her car at 24 miles an hour and hit her boyfriend intentionally or unintentionally and then leave him there to freeze to death and die? Or did John somehow not seen by, like everyone's lying, including the witnesses outside the house, that he went to the house, immediately got beaten up in seconds, and then proceeded to get deadlift, and then left in the house for some reason, but somehow his cell phone data doesn't show that he was in the house, and somehow his cell battery like goes colder, and then basically everyone leaves, and leaves Brian out, believes like Albert and his wife to deadlift the unconscious man and put him on the side past 2:30 before, right, and somehow bury snow over him without showing any sort of footprints or movement or anything like that, or proceeded to like lift him up immediately, beat him up immediately, and lift him up and throw him right next to Karen Reed's car while she's still at the scene, and she doesn't notice like 3-4 people carrying a 6'2" man across the yard.
Sherry, reasonable doubt is not any doubt. I think people get confused reasonable doubt with any doubt. And even if Proctor did a terrible, horrible investigation, like people want to claim, which unfortunately he wasn't the only person investigating. There's multiple officers investigating.
Unfortunately, Sherry's using a talking point by a lot of law tubers and some
aware.
people that keeps on saying it's a terrible investigation, but yet they don't want to go with the actual evidence of the case. I outlined the evidence. They have basically cell phone data showing the last movements of John O'Keefe.
And her car backs up.
Let me finish the evidence.
Go for it, Tim.
They have the GPS of the last location. They have a hair on the back of his car. They have basically her own words stating that she hit him in the back, thought she hit him in the knee, and that he dropped on the floor. They have her incriminating words of saying that she was expecting to see there. She has 4 witnesses admitting that she thought that she hit him, or said, I hit him. They have actual taillight lights and around the area. They also have microscopic taillight pieces around on his clothes. They also have the fact that there is glass on the back of a car that could be from the cocktail glass. There are also other things, including that she was very drunk at the time. There's multiple things pointing, and also
the
now
FBI ended their investigation, clearing the cops and all the witnesses.
And one more thing is that apparently now they have a black box that says in the car that says that they have an impact event around the time Ian Wolfen says that happened. This is evidence that clearly there's people have been convicted for far less with the amounts of evidence. So when people come up to me and say, well, the investigation was flawed, I'm like, tell me how the investigation was flawed when you have all this evidence pointing to this woman's guilt. I think people need to stop listening to these law tubers like they're freaking great lawyers. In the end of the day, these are a lot of civil practice attorneys, not actual criminal attorneys that have defended people and gotten them out of jail. And that is the truth. And there's a huge difference between a civil attorney and a criminal attorney, a good criminal attorney. And let me tell you that much. And I think a lot of people like to sit back and pretend they're smarter than what they are. But the truth of the matter is, I don't think freaking lawyer would hold water to comparison to Hank Brennan or Alan Jackson for that matter, because I think Alan Jackson is a very good attorney, by the way.
He wouldn't,
but I just because he's I gotta give the devil their dues here. I think Alan Jackson is actually a good attorney. I think Hank Brennan's a good attorney.
I think Alan Jackson's making personal mistakes in this because it looks like he's personally invested, and that's where he fucked up.
Yeah. I'm not sure of using a talking part. I just think
I get what your argument is, but that argument has been long debunked because you can take everything that Proctor touched, and this is the way I explain it to people, right? You could take everything that Proctor ever touched in this investigation out of it and still convict her.
Okay? Yeah, the problem is that a lot of the points, they don't want to give you a timeline of events for Proctor. You can go with a timeline of events of Karen Read, but if you ask people about a flawed investigation with Proctor, show me the timeline of events where he had the opportunity to plant taillight pieces. Show me the timeline of events where he had the opportunity to put a hair. Meanwhile, we have actual video of surveillance that shows that now that the snow was covering a taillight and then the snow fell off, showing the broken taillight, basically exposing the defense lie, making it their false claims that Proctor broke the taillight. Tell me how the fact that Kerry Roberts' own statement states that there was a piece of metal hanging out from that particular area. Meanwhile, it matches exactly what was shown in the evidence on the taillight. This is all that and if you go with that particular piece of evidence, you have to admit that, if the taillight is broken and it's not broken by her backing into John, how did it break between the hours of, 12:32 and some change in seconds to 5:30 or whatever the time she pulled out? And the only conclusion you can basically go with is that she hit something and she hit John. And that's a very simple thought process. This is logic. This is Occam razor.
I mean, here's the thing. Maybe Sherry's on the fence. Maybe that's why she's here, guys. And it's our job to show her that maybe some of the places that she's been getting her information from haven't been openly honest with her. You know what I'm saying? This is
I get it. And I'm not dogging Sherry. I mean, I'm very
no. I get it. You're giving them. You're giving.
I'm not denigrating her. I'm just saying that these are the facts of the case. And Proctor, tell me the timeline when Mr. Proctor had the opportunity and to do this. Also, give me the motive. Why would he put his, to be honest with you, listen, when I look at Proctor, everyone makes him sound like this master criminal, like he's going to manipulate. This is what the defense allegation is. They're alleging that Proctor not only manipulated video data that can trick experts for some reason, like actual experts that have been in the computer field for over 20 years, but not only that, somehow puts a hair on the back of a car without any surveillance showing him, breaks a taillight piece without anyone seeing him, grabs the taillight pieces, somehow puts it buries it around John's body, and somehow not seen by anyone. Based upon his text messages, I don't believe Mr. Proctor is a master criminal mind. I think he is a guy who made a lot of mistakes, unfortunately. He was very unprofessional, but I don't believe he's a master criminal. So, I mean, you got to think Occam's razor, and you got to think very simple explanations, usually how it goes.
We do have a friendly bunch here, Sherry, and if you are, clearly you have some questions about this, and we're happy to oblige with answering your questions. on this. I think half the problem is law tubers like to make it. Christina, do me a favor. Email me the pictures so I can show them so they understand. It's twistedtragedies3@gmail. It's hard for me to get Facebook up on my screen, but if you email them to me, I can probably easily show them to the class because you guys need to see this. This is what the snow looked like that night. Okay, so I'm going to show you guys what Christina sent me, which is exactly what it looked like in that storm.
Yeah.
When there is a buffer zone, but let me get to this. So Sherry clearly has some questions, right? And the problem, as most of you know, is the law tubers. And this really burns me. You guys know how bad this chaps my ass as someone who was almost an attorney, wanted to be an attorney, and just, with my kids' illness took me a different path. For me, it burns me because I have a knowledge probably the same or more than some of these law tubers when it comes to the law. And especially because some of them fail to tell people that they have been out of practicing law for many years and just strictly do YouTube. Also because they fail to explain that they're civil attorneys, not criminal attorneys, very different in nature. 3, most of them are out of state. And 4, they know how much money FKR brings in and how many viewers. And that's what they're looking for, right? But the problem is they can scream till the cows come home that it was a terrible, awful, terrible investigation. But Proctor has no bearing over Karen's car data. You know who did? You know who pulled the information from Karen's car data in the first trial to tell us that she was at 75% acceleration with a 5-degree movement of her steering wheel, that she backed up 60 feet at 24.2 or 3 miles per hour? It was the defense team. The defense team did the chip on, chip off. That's where that information came from, was the defense team. You cannot alter that information, right? So if you just take her car data and John's phone data, and you just take everything else away, that car backs up, and within seconds, John's phone stops moving forever in the spot he is later found in after 6. And throughout all of that time, his phone battery temperature goes down and down and down, proving it never goes in anywhere, never gets picked up, never moves. Because the second that it does move, when Kerry Roberts gets the phone after 6 in the morning, when they pick John up, that phone battery goes up.
Yeah, and that's at that point I want to point out is that if you basically have a situation where the cell phone battery is going down and down and down throughout the entire night, that destroys the whole defense's theory that he's in the house, because obviously if you're in a house of 70-something degrees, your cell phone battery is not going to drop by that temperature. So the fact is like you have to realize what the defense is doing, and the defense is basically grasping at anything they can, and basically playing. And this is why I call Jackson, distraction Jackson. He is like a magician. He is trying to make your eyes focus here while he hides the quarter behind your ear. And that's basically what he's doing. And this is what the defense is doing. And unless he is trying to somehow bore the jury to just accept his words or something like that. And it's just, and then also I would like to point out one more thing, because I got to go. I got work.
Yeah.
Look at Karen Reed's affect. And that should tell you a lot of and how her behavior is. Does an innocent person leave 2 children who are, just found out their caregiver just died by themselves and just rushes off and leaves them behind? Does a person who cares, smiles throughout a murder trial about their significant other? Realize this, I'm a person that has gone through loss, real loss. I had both my parents die. Both of them are dead. I have friends who have died. Online, I have heels in the air. That took me out for a couple of days. Still to this day, this is a person I've never met in real life, but this was a person I knew for almost a year and a half on this platform. And now whenever I bring that up, it actually kind of doesn't make me happy at all. No. I was on her last stream before she died. And I can tell you,
she died, and that got me, dude.
And the fact is that my affect, if I heard about her death and her autopsy or whatever, there wouldn't be a smile on my face. No. There'd be like a real attempt not to break down. Yeah. And that's the thing. Like, you have to say to yourself, is this the affect of a normal person, or is this the affect of a person that has no morals or no sort of soul? Because it's just disgusting. But anyway, that's my last words. I just say, look at and the jury's going to look at someone's affect. And that is how they judge someone also when they're guilty. If they're smiling at their own murder trial, that's a problem. But anyway, you guys have a good one.
Bye, B Tim. Pop in on us when you can.
All right. Bye.
Bye. I mean, Francesca brings up a great point here too. And I was actually on the stream with Heels when the accident happened, literally just like this, just like me and B Tim just were. And that was so hard. And like I thought about not streaming the trial for a couple days after that, but I was like, no, Heels wanted a resolution to this case. And she took a lot of abuse because of her stance on this case. And so I was going to finish it one way or another. And I did. And then here we are. So like now I have the, weight on my shoulder of having to finish it no matter what. Like, and not just for her, for many other reasons. But I do think it's funny. Francesca makes a good point. Yep, me and Ange were there. And we didn't even know. We had no idea what to do. Like, you know what I mean? Like we thought, we were told she was going to be fine. It was, she just fell, maybe broke her hip. It was tough. It was definitely tough. Clearly Court TV is having issues with their feed right now. So we'll just wait a second anyway. Oh, there it goes. But she brings up a very good point, is that when the defense did the chip on, chip off in the first trial, they missed gigabytes data, lots of data, so that this time it had to be done again. And you hear the talking points from the cult, which are like, wow, if they did it again, they added data. No, because the defense expert is allowed to be right there with the other expert, as was the Commonwealth when the defense experts did the chip on, chip off in the first trial. They were allowed to be there and looking and watching everything that's being done. So the data itself cannot just be changed, okay? John's phone data, Karen's car data cannot be changed. You can take the taillight completely out of it. I don't give a shit about the taillight. Take the taillight, throw it out the window for all I care. If people want to sit there and harp on like, oh, the taillight. First of all, Proctor would have had to plant taillight underneath snow, mind you, in front of an entire CERT team. Not only is that not probable, it's definitely not plausible. So the fact that like there's no timeline for him to have been able to do that, never mind the fact that he never touches the taillight. So there's that. Also, you have to believe that 50 plus people, including, all of the firefighters and all of the EMTs and the civilian witnesses, are all in on a grand conspiracy to frame Karen Read, most of which never knew who she was. And the other half of them actually knew her, liked her. You know what I'm saying? So it's just weird to me, just like weird that these law tubers, of course, are not going to point these things out because it doesn't help their narrative. Now, listen, I have no problem, as you guys know, pointing out something that I think is wrong on either side, whether it's the Commonwealth or the defense, whether I think someone's doing bad one way or another. I have some serious issues with the judge in general. Like I had some serious issues with some of the things Lally didn't ask or didn't say in the first trial. So you know me, I don't have a problem saying when I think something's off here. I do think that David Yannetti probably gets the shit end of the stick here because was a well-respected attorney here in Massachusetts. And I say was because of the many, many attorneys that I have spoken to in this debacle of covering this since 2023, and living here and unfortunately being a part of this. A lot of them have told me his reputation has been flushed down the tubes, and more so because of the stunts that Ellen Jackson has pulled, and that it's on David Yannetti's license. You know what I'm saying? That's the other problem. And by the way, Joy, you weren't the only one. I literally got kicked out of my own live stream 57 times yesterday. I kid you not, over a dozen or more times. I got kicked out of my own live stream because of Xfinity. And if it wasn't for Freak here, because what we do to keep the bandwidth sort of off of my computer from it sort of conking out on you guys, because my laptop's at least 4 years old. I desperately need a new laptop or high powered computer. And obviously I do not have the funds for that. So I work with what I got. But if it wasn't for Freak, he streams it and then I share screen. So if it wasn't for him, my entire stream would have went down a billion times yesterday. His thing is what keeps it up while I'm being booted out. So you weren't the only one. I think there was a whole thing happening with Xfinity for sure. Maybe she's going to give us an answer about yesterday. I need to see
counsel at sidebar, please.
Oh, we're already at everyone to guess your sidebar amounts today. I forgot. Everybody put in your guesses. I'm still going to stick with 11 today. We went over yesterday, but I'm going to go with 11. So let me just make this. They did not lift the buffer zone, but the mob has been told otherwise by their dear leader. So there's what with most of them are scrapes, not like deep scratches. The pictures look very misleading because the defense darkened the wounds to make them look like they were deeper. They are scratches and scrapes. You have to remember, glass found next to John in on the bumper of the car. And now we think he might have had both glasses, not just one glass, but two glasses. Karen's glass, because Karen said that he took her glass. So maybe he took her glass and his own glass. So he might have had two glasses when this happened. That's a lot of glass, which, as Karen said, she pulled a piece of glass out of his nose. Now, Karen said that. No one else said that. She said she pulled a piece of glass out of his nose, which we know there was a little scratch and scrape on his nose. Now, if you're holding a glass and the thing obliterates and there's, you're being moved around, yeah, you can definitely get some scrapes and some scratches from that glass getting inside your clothing and scraping you and scratching you. Now, could some of it been of the taillight? Absolutely, it could have. The way it broke. Some of it could have been from the frozen ground or anything nearby. We're probably never going to know what each scratch was, but what we do know is it's not a dog. There's no puncture wounds or bottom jaw. The teeth can't be this far apart. Like, yeah, the buffer zone is literally the same. It's this, like the judge, I read the order yesterday. Nothing in that order says that the buffer zone has been changed. Nothing in it. Nothing. She just makes it more detailed. You still can't just hang out in the buffer zone screaming and yelling. So I don't know what, they still can't be on the courthouse property or the sidewalks near the courthouse. And there is a part of his arm that lines up perfectly with a piece of that taillight that they found, because it has like two indentations on the back of it. It literally lines right up with that piece of taillight. Oh my God. And I called it, Joy. Of course I did. Right when he was doing it, I was like, this is going to make a juror sick. And what happened? Just seconds later, they had to stop because it made a juror sick. I called it. It was a very risky move. And that's exactly what I said. You're going to make a juror sick. They're not going to, be too kindly on that. Like, oh God, that was it. That was such a hard day. Such a fucking hard day. Right? I got booted more than the sidebars they had in court yesterday. For real. Like, and that's another thing. How many conspiracies? You know what I'm saying? However, how many people and not a single person flipped in all that time? Come on now. Also, I didn't do the spiel this morning because I was too busy telling you guys that Kevin was home and safe, and we would like more prayers for Kevin, please, because he's still got a long fight ahead of him. Cancer's no joke. It's no joke, and it is doing a lot of damage to Kevin's spine. So I would ask you please still say some prayers for Kevin, just ongoingly, because he could definitely use those prayers for sure. If you want to donate to the channel, happy Friday, by the way, everybody, TGIF, right? You can do so these ways. We are not monetized, obviously, so this is the only way the channel gets support, and we could really use the support. It's been very slow lately. You can do it Cash App, Venmo, PayPal. We also have a link for those people who don't have any of the payment apps for you to just click on, and you can use credit or debit. Freak will put that in the chat for you guys. And we also have an Apple Pay link. And Revolut, for those of you who are out of country, in different countries all over the world, Revolut literally works to send or receive money. You can also invest on it, which is kind of cool, which I obviously have not done. You have to have the money to do that, but it's kind of cool. You can send or receive money from one to another. So somebody from England can send money to the US. Somebody from the US can send money to China. It's pretty awesome. Even if Japanese yen, I find it to be pretty cool. That's for sure. Canada. I mean, there's so many countries involved with that. It's a very cool thing to have. One of my friends was like, get Revolut because you have viewers from all over the world so that, they might want to help out. And we also have the good old wish list and e-gift cards that some people prefer, which I save. I save most. I save most unless I need something. I save the e-gift cards to Amazon you guys send me because I want to get another air conditioner for my house. I only have one and definitely need two. That was the problem. You know what I mean? Like, they could hear them screaming while they were trying to deliberate. And like, that should never happen. Ever. Sticking with 12? Yeah, we're bringing out the clowns early. You know what I'm saying? Like, that's the thing. They need some clarity on the buffer zone. I think the judge should have been a little clearer about what was happening around it. But, you know, there was a meeting to discuss clarity on buffer zone. They can be on the side where the registry of deeds are. Yeah, across the street. But they can't just be standing directly in the sidewalk either. That was very clear in the order. You know what, though? That's, you know, you just take it, right? And then we do better next time. There's nothing you can do to go back in time, believe me. I have regrets on certain things as well. But you know what? I believe Heels is up there, and she's very proud of all of us. You know, you can be critical. That's okay. You know, and she had very strong feelings on certain cases. But she's a good person, and she's the one who pushed me to keep going with my channel, especially when, you know, I originally thought maybe possibly this could have been a cover-up in the very beginning when there was no evidence, you know, and when I realized there was evidence, and then I got harassed into oblivion, and I changed my, you know, opinion after all of the evidence came out, all of that. I went from someone who was having an income stream on my stream to cover the costs, which are, as Kevin pointed out yesterday in his like comeback stream, there are a lot of costs associated with doing this. You can't do this for free. Like, and trying to cover the costs and then maybe trying to pick up a couple bucks after that, it's difficult, right? And when you go from like getting there, you're just about there, to being attacked and the entire thing being wiped out, she was the one that sort of pushed me to keep going, whether it was the harassment or she was like, you're standing for something important, Elise, and your channel will get there. It will get there. You got to just keep going. And she pushed me and pushed me to just keep going, keep going. You can do this. You can do this. Like, and I'll never forget that, because if it wasn't for her pushing, I might not be here today. I took a lot of heavy damage emotionally and mentally with the harassment, and still do, but I got a better way of dealing with it now. So, you know, so WCVB is reporting, on my way to the courthouse, I noticed state police talking with demonstrators. It appears they're still trying to work out how the buffer zone will work under a supplemental order. Interesting. Yeah, we want to definitely keep saying prayers for Kevin. You know what I'm saying? Right? We want to keep saying those prayers. It's almost more difficult for him to be home, though, because now he's got to transport back and forth for the radiation, and that's difficult for him. It's in his spine, guys. Like, sitting like that and being in a car, like, that's difficult for him. It would have been better if they kept him and just, you know, for him, it would have been. But we are glad to see him, of course, you know. I don't think the prosecution will be done next week. No. No, I do not. And yeah, that definitely doesn't mean there is a cover-up, for sure. There's a lot of people who've said some bad things about Karen at this point, including me being one of them. She just clearly doesn't care about anybody else, you know? Yeah, I watched it. I watched it this morning when I woke up this morning. I was fast asleep at that point, but you guys know, I had a long emotional day yesterday. So I was very tired. But we always send much love to Kevin. And just to like jump on, like I watched, you know, Kevin's speech, and he wrapped it up so perfectly, but just to like sort of go off of some of the things that Kevin said, I think it's really important that people unify and come as one to fight this kind of bullying and mob tactics against people, because like he said, an indictment isn't going to do it. Like, yes, locking up the leader of this nonsensical fight against innocent people and anybody who supports them is just shitty all around. It's awful. But that's not going to stop some of the main mob members from doing it. What will stop it is the public together saying this behavior is not okay. And not seriously, but for those of you who are, just like Kevin said, what are you waiting for? We definitely need the help. We need the voices. We need the help. So if you're not standing up and saying something, and you can, You can't, and you're worried for your family because that's what I hear the most. But if you can, and you're in a position to, what are you waiting? What are you waiting for?
Good morning again, Council. Good morning again, Ms. Reed.
We are better together than we are apart, as one.
I appreciate your patience. I have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes and nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. I have one other important instruction.
Whole day.
It's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk. Don't make any facial expressions. No muttering under your breath. No audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that. And out of respect to the lawyers who worked so hard to get this case before. Thank you very much. With that, Mr. Brennan, your first witness, please.
She's basically telling me to mutter under her breath.
Offering a stipulation that's agreed to between the parties.
Okay, can we
any
turn
noises
down, please?
Shock facial expressions, making any noises, talking, muttering things under your breath. That means that there's probably not some favorable things towards Karen and that jury.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Reed, the defendant, in the above captioned matter. Both parties respectfully stipulate to the following. The 2 Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scordi Bello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
Thank you.
Huh.
Yes, thank you.
With that, Your Honor, I'd like to introduce and play clip number 21.
Okay. Paul.
I probably am too loud. I'm sorry.
Hold on 1 second, please. I just want that.
Clip. See it.
Can the jurors hear better with that on?
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Good clip. Remember I said yesterday they should have played this clip yesterday.
So you need this marked.
Yes. We have the item.
Showing that the glass clearly is something that causes the scratch, that has caused some of the scratches on John. And that Karen saying she pulled glass and it was gushing blood, man, he would have still been alive.
Your Honor, the Commonwealth calls Andre Ford to the stand.
Who? Sorry, I was talking. Guess we'll find out anyway. The guy's got to say his name and then spell it. So, yeah. When they tried to say he was, right? Isn't that Trooper Proctor? And it wasn't. Shocker, huh? Yeah, John was already had no signs of life when they found him. Didn't happen because Carrie's the one that brushed the snow off his face. Andre.
Morning. Hey, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
Yeah, my name is Andre Porto, last name spelled Porto.
And what do you do for work, sir?
I'm a forensic scientist too in the DNA unit at the Massachusetts State Police Crime Lab.
And where did you go to school?
I received my undergraduate Bachelor of Science in Microbiology from the University of Massachusetts in Amherst. And then I received a Master of Science in Biomedical Forensic Sciences at the Boston University School of Medicine.
Now, following your education, where did you go to work?
I started at the Massachusetts State Police Crime Lab in the DNA unit.
And how long have you worked at the state lab?
Slow down.
Oh, yeah, sorry.
How long have you worked at the state lab, sir?
Since September 2019.
Now, when you joined the lab, what was your position and title that you were initially hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury your duties and responsibilities as a forensic scientist 1?
Sure. So a forensic scientist 1 is a training position where we're hired and we undergo an extensive training program where we do undergo the analysis process in training casework samples, where we learn how to do the lab work and analyze profiles. And at the end of this training, I took a competency test to make sure that I was able to accurately conduct the DNA analysis process. And once I passed that, I was then put on to do casework. And a year after completing both my competency tests and a year after my hire date, I was then promoted to a forensic scientist 2.
And so you're currently a forensic scientist 2, is that correct?
Correct.
And what is the difference between a forensic scientist 1 and a forensic scientist 2?
So a forensic scientist 2 is just the automatic promotion that you get after a year of hire and passing the initial competency test. And we're able to do the DNA process in casework samples.
Now, so what type of analysis do you currently do at the Massachusetts State Police Crime Laboratory?
I can do the DNA analysis process in casework and known samples. That includes the lab work as well as analyzing the DNA profiles that are generated from the work.
Now, first, just in general terms, but specifically with reference to DNA analysis, can you explain to the jury how is that analysis performed?
Sure. So there's 4 steps in the analysis process. The first step is extraction, where we apply heat and chemicals to the samples to break open the cells and release that DNA to be available for use. Step 2 is called quantitation, where we take a small sample of that extracted DNA to estimate, and we use chemicals and run it through an instrument to estimate how much DNA we extracted. And then we proceed to step 3, which is called amplification. And that's basically, think of it as a molecular photocopier, where we target specific areas of the DNA to make millions of copies of it. And then we run it through, go to detection, where we run it through an instrument, and we generate the DNA profile as an electronic file on a computer.
Now, is the state lab where you work accredited?
Yes, it is.
And by whom?
We are accredited by an organization called ANAB, which stands for ANSI, National Accreditation Board, and ANSI stands for American National Standards Institute.
I need you to slow down, please.
Sorry.
Please.
Sorry.
Now, Mr. Porto, are there steps taken in your lab during that process that you were just explaining to prevent against contamination?
Yes, there are.
And can you explain what those are?
Sure. So there are various steps. One step to prevent contamination between analysts would be to bleach and wipe down the workstations before use and after. Another way to prevent DNA transfer from analysts to the samples is to wear personal protective equipment, such as lab coats, gloves, masks, hairnets, and beard guards. And a way to prevent transfer from sample to sample would be to frequently change gloves, as well as only have one sample open at a time.
Now, with your work at the lab, is there a review process that your work undergoes?
Yes, there is.
And can you describe that process to the jury?
Sure. So once I complete my work, the file undergoes 2 types of reviews. The first is a technical review, where another qualified analyst will take the file and they'll do their own independent assessment and make sure that they come up with the conclusions and that they agree with the conclusions that I reached. And they'll also make sure that all the protocols were followed and every decision is scientifically sound. Once that review is completed, it undergoes an administrative review, where another qualified analyst will then look through the file and they look for clerical errors, such as typos or missing page numbers or missing case numbers. Once those 2 reviews are completed, the results can then be reported out.
Now, as a part of that accreditation process that you were speaking about a few moments ago, do you undergo anything called proficiency testing?
Yes, I do.
And can you explain to the jury what that proficiency testing process consists of?
Yeah, so a proficiency test is a test that's administered twice a year by an external vendor. And the results of this test are not known to the analyst at the time. And we basically treat it like it's a real case where it undergoes the analysis process as if it were a real case. And this test is used to show that the analyst is demonstrates ongoing competency in the DNA analysis process. And successful completion of the test is required to maintain qualification as an analyst.
And what areas do you specifically undergo proficiency testing in?
DNA analysis.
And have you successfully completed each of those proficiency tests that you've taken?
Yes.
Now, Mr. Porto, could you explain to the jury what exactly is DNA?
Yeah, so DNA stands for deoxyribonucleic acid, and it's basically the building block that makes us who we are. We each have 2 copies of our DNA, one that we inherit from mom and one that we inherit from dad. And this combination makes sure that, barring with the exception of identical twins, we all have different DNA.
And is DNA the same in every cell of a person's body?
Yes. So what that means is if I were to take a blood sample and a saliva sample from the same person, the same DNA profile will be generated.
Now, you spoke a bit earlier about the different steps included in the DNA testing. If you could, just a little bit slower, go through each of those 4 steps again for the jury.
Sure. So like I said, it's a 4-step process. So extraction, quantitation, amplification, and detection. So extraction, we use chemicals and heat to burst open the cells to make that DNA available for use. Quantitation, step 2, we take a small sample of that extracted DNA. We use a different set of chemicals and an instrument to estimate how much DNA is available for use. Amplification is the 3rd step, which I mentioned is the basically molecular photocopier, where it makes millions of copies of specific areas of the DNA. And then the 4th and last step is detection, where we run those amplified copies through an instrument, and we generate the DNA profile as an electronic file on the computer.
Now, Mr. Porto, what is STR?
So STR stands for short tandem repeats, and they're the locations that we're making the millions of copies of.
Now, in your work at the lab, you have something that's referred to as a known item.
Yes.
And can you explain to the jury what a known item is?
Sure. So a known item is an item that's taken directly from a person to be used as a reference sample, so we know what the source of that profile is.
And conversely, what is a questioned item?
A questioned item is an item that's taken, let's say, from a crime scene where we don't know what the source is.
Now, do you also have terminology within your lab as far as a parent versus a child item?
Yes, we do.
And can you explain how those labels are and how they reference to what you do in your work?
Sure. So a parent item is, for example, the original item, and the child is a sample of that item. So for example, this box of tissues would be the parent item, and if you were to swab the outside, the swab would be the child item. So the box of tissues would receive, let's say, an item of 1-1. The swabbing of the outside would receive an item of 1-1.1.
Now, what are positive and negative controls?
Yeah, so a positive control is a control that has it's a known sample with a known DNA profile that we use in every step of the DNA analysis process to make sure that each step and instrument worked as expected and properly. And then a negative control is a sample that has no DNA in it. It only receives the chemicals that we use. And that's to ensure that the chemicals that we're using don't have any DNA inherent to them.
Now, when you as an analyst or a forensic scientist too are assigned work within the DNA unit, where do you retrieve that evidence from?
Yeah, so I retrieve it from a locked cold room that's only accessible via keycard.
Now, why are items kept in cold storage?
Yeah, the cold storage helps preserve the DNA for long-term storage.
And as far as the heat versus the cold, why is it that it's specifically kept, or why does the coldness of the storage room help preserve the item?
The cold can help prevent, let's say, growth of bacteria and mold that can degrade DNA.
And what does heat do conversely in reference to an item of forensic value?
Heat can help degrade DNA and also promotes bacterial and mold growth that can further degrade that DNA.
Now, when you receive an item from the cold storage, how is that item typically packaged when you retrieve it from there?
Sure. So the item comes in these plastic, clear, transparent plastic sealed containers that has a label with a case number on it. And inside of that, each sample is within like a small plastic tube that has a label with that case number and item number.
Now, at some point, were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes, I did.
And what type of work in general terms were you assigned to do in this case?
I was assigned to do the DNA analysis process.
And that was on several items, is that correct?
Correct.
And could you explain to the jury the sort of the process that you used to analyze evidence in this case?
Sure. So the case underwent the 4 steps that I explained before. So extraction, quantitation, amplification, and detection.
And there was a known standard that was done in this case, specifically in item number 8-1.1.1. Is that correct?
Correct.
And did another analyst test and report the results from the known blood standard from that item 8-1.1.1?
Correct.
And how is that done?
Yeah, so that undergoes the same process that I explained. It'll go through the 4 steps: extraction, quantitation, amplification, detection. And then the analysts that did the interpretation and reported that out, the known standard out, they went through the profile to make sure that it's one person or single source. And once that went through the review process that I explained, so technical and administrative review, and once that was all completed, the standard was available to be used for comparisons.
And to whom was that known standard identified as belonging to?
John O'Keefe.
Now, you used the word in there as far as a single source. Can you explain to the jury what your understanding of that term is based on your training and experience?
Sure. So a single source is just a DNA profile that has one contributor to it. So only one person contributed DNA to that profile.
What exactly is a DNA profile?
Yeah, so a DNA profile is basically the combination of all of the locations that we amplified during the 3rd step of the process. And it's basically, you can think of it as like a chart, like an EKG, where it has peaks and valleys, and each peak has a specific number. And the DNA profile is just a combination of all those numbers put together.
Now, can you explain to the jury in general terms, to start with, the process of comparison between a known standard and a questioned or unknown standard?
Sure. So first, I did the analysis on the question items. I did the 4 steps. I analyzed the profiles that were generated. I then interpreted, make sure that I could determine the number of contributors. And once that was completed, I then used the standard that was available and compared them to all the profiles that were suitable for comparison.
Now, sir, starting with item 3-1.1, what was that a sample from?
That was a sample from taillight passenger.
And from a specific vehicle, is that correct?
Correct.
And what, if any, information were you given as to that vehicle that the swab from the taillight was from?
Do you mean like the license plate?
Yes.
Could I refer to my notes?
Yes.
Thank you.
Your Honor, with the court's permission, this is a little detail part of the testimony.
I don't have a problem. Does the defense object?
I do not.
Okay, thank you.
Thank you, Your Honor.
So the license plate was 3G6684. Right, I'm sorry, 3GC684.
Now, with reference to the swab from the taillight, were you able to generate a DNA profile from that item?
I was. And
from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least, so sorry. I'll just restart. So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least 510 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, what does that mean?
So an inclusion is basically when I look at the question DNA profile that was generated, and I compare it to the known DNA profile. And if the characteristics of the known profile are consistent with the characteristics observed in the question DNA profile, that's an inclusion.
Now, as far as that number, 510 nonillion, how many zeros in that number?
So a nonillion is a 1 followed by 30 zeros.
Now, that profile, in addition to Mr. O'Keefe's profile, also had 2 unknown contributors, correct?
Correct.
Now, was that item also submitted to an outside vendor named Bodhi Technologies for further analysis?
Correct.
And with reference to your comparative analysis from the profile from this item to Mr. O'Keefe profile, if you could again just expound upon what does inclusion mean?
Yeah, so an inclusion, I compared the known standard that I had available for use from John O'Keefe to the DNA profile generated from the tail light. And the DNA profile was, if that was consistent with the DNA profile that I observed in the questioned item, and that's what an inclusion means.
Now, regarding item 3-6, what is the description of that item?
Yeah, so 3-6 is a root end of hair from exterior passenger side rear panel.
And is that the same vehicle as far as the taillight sample?
Correct.
Now, with respect to hair in general, there's a root end and a shaft end, correct?
Correct.
And what limitations does your lab have with regard to DNA testing of hair?
So when we test hair, we're actually, the root end of the hair, we're looking at any potential skin cells that might be attached to the root end. So that's where the DNA that we're looking for is coming from. And if there's not too many, yeah.
Are you familiar with the term based on your training experience known as autosomal DNA?
Yes.
And can you describe for the jury what your understanding of that term is?
Yeah, so autosomal DNA is DNA that's located in the nucleus of the cell, and that's the DNA that we inherit from both mom and dad.
Now, are you also familiar, based on your training experience, with a term known as mitochondrial DNA?
Yes.
And can you please explain to the jury what your understanding of the term mitochondrial DNA is?
Yeah, so mitochondrial DNA is DNA that's found in the mitochondria of a cell, and we inherit that from the mother.
It may be somewhat evident, but could you please explain to the jury sort of the difference between autosomal DNA on the one hand and mitochondrial DNA on the other?
Yeah, so like I said, the autosomal DNA is the one that we have 2 copies of, where we inherit one from mom and one from dad. And then the mitochondrial DNA is a circular DNA that we just inherit from mom.
Now, is the Massachusetts State Police Crime Lab equipped to perform mitochondrial DNA testing?
No, we're not.
Now, was the DNA extract from the hair also sent to that external vendor, Bodhi Technologies in Lorton, Virginia?
I'm not sure if the extract was sent, but I know that the shaft of the hair was sent to Bodhi.
Now, what testing did you perform on the hair?
I did the regular DNA analysis process on the root end of the hair.
And that was done prior to it being shipped to that external vendor, is that correct?
Correct.
And what conclusions were you able to draw from the testing that you did on the hair?
Yeah, so there was no human DNA detected, and STR analysis was not performed.
Now, what does that mean, sir?
Yeah, so it means that I didn't detect any human DNA. So there might be DNA on there, but it was below what our instrumentation could detect.
Now, turning your attention to item 3-2.1.1, what is the description related to that item, sir?
It's a sample from the exterior of broken drinking glass.
And is there any further indication as far as the broken drinking glass, as far as where it was recovered?
Oh, yeah, 34 Fairview Road.
And were you able to generate a DNA profile from this item, the drinking glass?
Yes, I was.
And from your comparative analysis from this question item to that of the known standard of John O'Keefe, what did you conclude?
Yeah, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 530 nonillion times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This supports an inclusion.
This is the last time I'll ask you this, but just if you could reiterate to the jury, what does an inclusion mean?
Yep, so an inclusion is when I compared the known standard to the question item, and if the profile in the known standard is consistent with the profile in the question profile, that's an inclusion.
And that number again, as far as 530 nonillion, how many zeros again in that number?
That's a 1 followed by 30 zeros.
Now, sir, if I could turn your attention to another item, 7-1.2.1. What is the description related to that item?
Sample from stain A on upper right leg of jeans.
And is there any further indication as to whom those jeans belong to?
John O'Keefe.
Now, were you also able to generate a DNA profile from this item, the stain A on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from the question item to that of the known standard of John O'Keefe, what did you conclude with reference to that item?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributors 2 and 3 are not suitable for comparison. The DNA profile from this item is at least 570 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. Now, turning your attention to item 7-1.3.1, what is the description related to that item?
Sample from stain B on upper right leg of jeans.
And same jeans as the previous item?
Yes.
Now, were you able to generate a DNA profile from this item, stain B on the upper right leg of the jeans of Mr. O'Keefe?
Yes, I was.
And from your comparative analysis from this questioned item to that of the known standard of John O'Keefe, what did you conclude?
Yep, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 660 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.4.1, and again, these items with the dash and the point, is that what you're referring to earlier as the parent-child relationship between items?
Yes.
And what is the description for 7-1.4.1?
Sample from stain C on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain C on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis of this question item, stain C, to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile is a mixture of at least 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile was interpreted as a mixture of 2 contributors. The DNA profile from this item is at least 830 non-million times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.5.1, what was the description of that?
Sample from stain D on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain D on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from this item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 670 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also do some testing on an item 7-1.6.1?
Yes, I did.
And what was the description associated with that item?
Sample from stain E on upper right leg of jeans.
And were you able to generate a DNA profile from that item, stain E, on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from that question item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides a support for an inclusion.
I used a different number there as far as a decillion. How many zeros is a decillion?
Yeah, a decillion is a 1 followed by 33 zeros.
Now, with each of those items that you just testified about as far as the genes, the question items from the stains on Mr. O'Keefe's jeans, those were each located on the right leg, correct?
Correct.
Now, did you also perform some analysis on item 7-1.7.1?
I did.
And what is the description associated with that item number?
Sample from unstained areas of the exterior of jeans.
Now, were you able to generate a DNA profile from that item from the unstained areas of the exterior of Mr. O'Keefe's jeans?
I was.
And from your comparative analysis from this questioned item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 4 contributors, including male DNA. The DNA profile from this item is at least 53 septillion times more likely if it originated from John O'Keefe and 3 unknown individuals than if it originated from 4 unknown, unrelated individuals. This provides support for an inclusion.
And again, sir, with that number, as far as 53 septillion times more likely, how many zeros in a septillion?
A septillion is a 1 followed by 24 zeros.
Now, sir, if I could turn your attention to what's listed as number 12 in your report, but item 7-18.4.1. Did you do some testing on that item as well?
Yes.
And what was the description associated with that?
Sample from stain C on top front of Gray's long sleeve shirt.
And the gray long sleeve shirt, is that attributed as belonging to a specific person?
Yes, John O'Keefe.
And were you able to generate a DNA profile from that item, specifically sample from stain C on the top front of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that questioned item from the shirt to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originated from a single contributor. The DNA profile from this item is at least 58 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And again, sir, that number, as far as 58 octillion times more likely, how many zeros in an octillion?
So an octillion is a 1 followed by 27 zeros.
Now, sir, if I could take you down to listed as 15 in your report, but did you do some testing on item 7-18.14.1?
I did.
And what was the description associated with that item?
So sample from stain L on back bottom right of gray long sleeve shirt.
And were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis with reference to that item, the sample from stain L on the back bottom right of the gray long sleeve shirt, in comparison to the DNA profile from the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 2 contributors, including male DNA. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also perform some analysis on an item numbered 7-18.17.1?
I did.
And what was the description associated with that item, sir?
Sample from unstained areas of exterior of gray long sleeve shirt.
And similarly, were you able to generate a DNA profile from that item, the sample from the unstained areas of the exterior of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 960 nonillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. I'm going to group a couple, 4 separate items from your report, starting with what's listed in your report as number 9 is item 7-3.1, correct?
Correct.
And what is the description associated with that item, sir?
Sample from stain D on right instep of sneaker.
And 11 from your report, you also did some analysis on item 7-18.3.1, is that correct?
Correct.
And what was the description associated with that?
Sample from stain B on top front of gray long sleeve shirt.
And item 7-18.7.1, do you see that as well?
Yes.
And what was the description associated with that item?
Sample from stain F on top front of gray long sleeve shirt.
And lastly, in this group, item 7-18.8.1, what was the description associated with that?
Sample from stain G on back left sleeve of gray long sleeve shirt.
And with respect to each of those last four samples from those items, were you able to generate a DNA profile with respect to each of those four?
Profiles were generated from them.
And what did you conclude based on the generation of those profiles with those four items?
Yeah, so the profiles that were generated were not suitable for comparison.
And if you could explain briefly to the jury, when you say not suitable for comparison, what do you mean by that?
Yeah, so for 7-3.1, it was a mixture of at least 5 contributors. And at the DNA unit, we validated, basically we tested and make sure that our protocols were we can only interpret mixtures of up to 4 contributors. So I determined that there were 5 contributors, so that makes it too complex for us to do comparisons to it. So it's not suitable for comparison for that reason. And the other 3 items, due to the quality of the profile, they were not suitable for comparison. And basically what that means is that there were such low amounts of DNA that was in the sample that there was a lack of information from the profiles themselves, so they weren't really suitable for comparisons.
And just to be clear, the item that you're referring to with the 5 possible contributors, that's a shoot, correct?
Correct.
Now, if I could turn your attention in your report to what you have listed as number 10, there are a number of different items listed there, correct?
Correct.
And starting with item 7-17.2.1, what is the description associated with that?
Sample from stain A on top front left of orange t-shirt.
And 7-17.3, what is the description associated with that?
Sample from stain B on top of front left of orange t-shirt.
And item 7-17.4.1, what is the description associated with that?
Sample from stain C on top front left of orange t-shirt.
And item 7-17.5.1, what is the description associated with that item number?
Sample from stain D on front bottom right of orange t-shirt.
And item 7-17.6.1, what is the description associated with that?
Sample from stain E on back left shoulder of orange t-shirt.
And so each of those respectively were samples taken from stains on the orange t-shirt of Mr. O'Keefe, correct?
Correct.
Now turning your attention to item 7-18.2.1, what is the description associated with that?
Sample from stain A on right sleeve of gray long sleeve shirt.
And item 7-18.5.1, what is the description associated with that?
Sample from stain D on center front of gray long sleeve shirt.
And item 7-18.6.1, what is the description associated with that?
Sample from stain E on center front of gray long sleeve shirt.
And item 7-18.9.1, did you generate a profile from that item as well?
Yes.
And what is the description associated with that?
Sample from stain H1 on back left of gray long sleeve shirt.
And item 7-18.10.1, what is the description associated with that?
Sample from stain H2 on back left of gray long sleeve shirt.
And item 7-18.11.1, what is the description associated with that?
Sample from stain I on back right shoulder of gray long sleeve shirt.
And item 7-18.12.1, what is the description associated with that?
Sample from stain J on back bottom right of gray long sleeve shirt.
And lastly, with this group search, item 7-18.13.1, what is the description associated with that?
Sample from stain K on back bottom right of gray long sleeve shirt.
And so each of those items beginning with 7-18 were associated with various stains taken from various areas on the gray long sleeve shirt of Mr. O'Keefe, correct?
Correct.
And with respect to each of those areas of the orange t-shirt and the gray long sleeve shirt, were you able to generate a DNA profile from those items?
I was.
And from your comparative analysis of each of the DNA profiles from those items to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as it originated from a single contributor. The DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
Now, again, if you could just remind the jury, when you say single source contributor, what does that mean?
Yeah, so a single source profile is a profile that has one contributor to it. So like one person contributed DNA to that profile.
And with respect to the number as far as 490 octillion times more likely, how many zeros are in that number?
So an octillion is a 1 followed by 27 zeros.
Now, lastly, sir, did you perform any analysis with reference to items numbered 8-2 and 8-3?
I did.
And what were the descriptions respectively for items 8-2 and 8-3?
So item 8-2 was right hand fingernail clippings from John O'Keefe, and item 8-3 were left hand fingernail clippings from John O'Keefe.
So fingernail clippings from both the right and left hand of Mr. O'Keefe.
Correct.
And were you able to generate a DNA profile from those item numbers, the right and left hand fingernail clippings of Mr. O'Keefe?
I was.
And based on, from your comparative analysis of the DNA profile from the right and left hand fingernail clippings, both of Mr. O'Keefe, taken in conjunction with the known standard of John O'Keefe, what did you conclude?
Yeah, so the male DNA profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
So with respect to each the right and left hand fingernail clippings of Mr. O'Keefe, both of those were identified by you or your analysis as a single source contributor, correct?
Correct.
And they were each 490 octillion times more likely to have originated from John O'Keefe than from an unknown, unrelated individual. Is that correct?
Correct.
Thank you. Thank you, sir. I have nothing further on.
Yes.
Good morning, sir.
Good morning.
Mr. Porto, I would like to start by asking you about item 3-1.1, which you've identified as a sample from the passenger side taillight of the vehicle. Can you orient yourself in your report to that item?
Yes.
And that, of course, was the passenger side taillight that was attached to the vehicle, correct?
Correct.
You were never asked to do any DNA comparison on any pieces of taillight connected with this case, correct?
Let me check my other report. For taillight, there was another item that was item 2-3.1, which is sampled from apparent glass on rear bumper, if that's what you're referencing.
Okay, so if I suggested to you that the taillight was plastic, that glass wouldn't have been the taillight, correct?
I don't have, that's beyond my scope of testing.
Gotcha. Okay. With regard to the passenger side taillight, you found that there were 3 contributors of DNA to that taillight attached to the vehicle, correct?
Correct.
One of those contributors appeared to be John O'Keefe. Is that fair to say?
He was included into
right.
the profile.
With regard to the other 2 contributors, who were they?
They could be anybody.
Were you ever asked to compare DNA samples from either Canton Police Detective Kevin Albert or Canton Police Chief Kenneth Berkowitz to the DNA profile?
Let's keep blaming the dead chief.
Analyzed
That's a theme.
From passenger side taillight.
Blame the dead chief. Come on, man. You want to blame the dead guy? Like how low can you go?
To the broken drinking glass, which is item 3-2.1.1. Do you see that in your report?
I do.
With regard to that, you came up with a DNA profile that also had 3 contributors, correct?
Correct.
One of those contributors appeared to be John O'Keefe, correct?
He was included, correct.
Who were the other 2 contributors?
I don't know. They could be anybody.
Were you ever asked with regard to that broken drinking glass to compare the DNA profile that you analyzed with the DNA of either Boston Police Sergeant Brian Albert or ATF agent Brian Higgins?
I was not.
So everybody's in on it? Got it.
Now, with regard to 7.1.2.1, or maybe it's 7-1.2.1, that's the stain A from the upper right leg of the jeans?
Correct.
All right. And you were aware, or you were told that those were the jeans that John O'Keefe was wearing on the morning in question when he was found?
Based on the sample description, that's what it seems.
All right. And it turned out that his DNA was on his own jeans, correct?
He was included in the profile.
All right. And that was unsurprising to you, correct? And with regard to that item, you found that there were 3 contributors of DNA, correct?
Correct.
With John O'Keefe being one of them.
He was included in the profile, yes.
And who were the other 2?
I don't know. They could be anybody.
Let's move on to stain B, also from the upper right leg of the jeans. That is 7-1.3.1. You see that in your report?
I do.
When you found a DNA profile, how many contributors of DNA were there?
3 contributors.
All right. And again, this was John O'Keefe's genes, correct?
Based on the description, yes.
So he was one of the 3 contributors.
He was included in the profile, yeah.
Who were the other 2?
I don't know. They could be anybody.
You dumbasses.
Moving on to stain C from the upper right leg of the jeans.
Medical personnel.
7-1.4.1. You see that in your report?
I do.
With regard to the DNA profile that you analyzed there, how many contributors of DNA were there to that profile?
And Karen?
At least 2, and it was interpreted as 2 contributors.
And again, this is the same pair of jeans that he was found in, correct?
Based on the description, yes.
And you said at least 2 contributors. It actually could have been more than 2.
Based on our protocols, I had to call it 2, and we determined it as 2, but it could be more than 2, yes.
Okay. Well, let's pay attention to the one that was not John O'Keefe, at least that one. Who contributed that DNA to his pants?
I don't know. It could be anybody.
Moving on to stain D, which is
I'm just gonna smash this out of the park.
7-1.5.
Could it have been medical personnel? Yes.
And if I can just put my glasses on.
Could it have been
make sure
Karen?
I read my own writing correctly. Actually,
Karen.
is it 7-15-1? Did I get that wrong the first time?
D?
I'm sorry?
Do you mean
Stain
stain
D? Stain D.
Stain D is 7-1.5.1.
Oh, I had it right the first time. Okay. With regard to that stain, you also got a DNA profile. And how many contributors were there to that DNA profile?
I interpret it as 3 contributors.
And again, this is John O'Keefe's genes, correct?
Correct.
He was one of the contributors to his own genes, correct?
He was included in the profile.
And with regard to that stain on the upper right leg of his jeans, who contributed the DNA to who were the other 2 contributors of DNA to that stain?
I don't know. They could be anybody.
Right. Why didn't the defense test it if they thought it was someone?
Finally,
Come on, man.
with regard to that upper right leg of the jeans, there was also a stain E, correct?
Correct.
How many contributors did you find to that DNA profile?
2 contributors.
One of which was John O'Keefe to his own genes, correct?
He was included, yes.
And who was the other contributor to that stain on the jeans?
It could be anybody. I don't know.
And by the way, just for the record, that was 7.1.6.1?
The defense didn't test it because they know that it's
1.6.1.
not going to be the people they want it to be.
Now,
which could kill their theory.
With regard to the unstained area of the exterior of the jeans, do you see item 7-1.7.1?
Yes.
You found a DNA profile with regard to that unstained area as well, correct?
Hospital staff,
How many
EMTs.
contributors of DNA were there to that unstained area of the jeans?
Definitely
I
one
interpreted it as 4 contributors.
crying,
And John
blubbering all
O'Keefe
over.
was one of those, correct?
He was included in the profile.
His own genes.
She jumped on
Based
top
on the
of him.
description, yes.
Who were the other 3 contributors to that DNA profile?
I don't know. It could be anybody.
And before we move on to the sneaker, I just wanted to ask you a question
Right?
about the
Yes, his own
passenger side
genes.
taillight that I neglected to ask you.
I agree.
That was the one where there were 3 contributors, correct? And again, I'm going back to 3-1.1.
Proctor and Buchanan did.
Correct.
Sorry to skip around, sir.
That's why you
not
haven't
trying to
heard him
make
say
this
that
any
yet.
more confusing than it is. With regard to the passenger side taillight and that DNA profile, are you able to determine when that DNA was deposited on the passenger side taillight that was attached to the vehicle?
No, I'm not.
Are you able to testify with any certainty that it
I'm
was
rolling
deposited
my
there,
eyes.
say, on January 28th or 29th of 2022?
No, I can't.
So consistent with your analysis of it, are you able to say whether it occurred prior to January 28th of 2022?
No, I can't.
Were you aware that that vehicle was John O'Keefe's girlfriend's vehicle?
I was not.
Were you provided any information about just how often he had been in and around that vehicle prior to January 28th of 2022?
Me too. I love you guys. I could have those
So
shittiest
moving
days.
on to
You guys make me laugh. And I'm having one of those days
3.1,
already.
which was the right instep of the sneaker, correct? You see that in your report?
Yep.
With regard to that particular stain, you noted how many contributors of DNA?
Yeah, it was interpreted as at least 5 contributors.
And when you have interpreted it as at least 5 contributors, what does that do to your ability to find out who contributed that DNA?
So based on our protocols, we're not able to do any comparisons to any mixtures that are 5 or more contributors. So it's not suitable for comparisons.
Okay, which means that with regard to the sneaker, at least, you couldn't even say whether John O'Keefe's DNA was on it, correct?
Correct.
And with regard to all 5, do you have any idea who contributed the DNA to that sneaker?
No, I don't.
Now, moving on to, I just have a couple more for you, sir. Moving on to what is labeled as stain L, which is 7-18.14.1, I believe. Do you see that in your report?
I do.
And that was a stain on the back bottom of his long sleeve shirt, correct?
Correct.
And were you told that the long sleeve shirt was his outer clothing when he was found?
I don't believe so.
How many contributors to that stain on the back bottom of his long sleeve shirt did you find in that DNA profile?
I interpreted it as 2 contributors.
And did you make any match with regard to either of those contributors or both?
I did comparisons, and John O'Keefe was included as one of the contributors.
Okay, so John O'Keefe was a contributor of DNA to his own long sleeve shirt, correct?
Based on the descriptions, correct.
All right, and whose other DNA was on that shirt?
I don't know.
And then finally, with regard to 7-18.17.1, that was an unstained area of the exterior of that shirt, correct? That same long sleeve shirt.
Correct.
And you tested that and got a DNA profile, correct?
Correct.
How many contributors were there to that DNA profile?
I interpreted it as 2 contributors.
Was John O'Keefe one of them?
He was included as one of the contributors.
Okay, so his DNA was found on his own shirt, correct?
Based on the description, correct.
And who contributed the other DNA profile to John O'Keefe's sweatshirt?
I don't know.
With regard to any of the stains on the upper right leg of the jeans, I counted 1, 2, 3, 4, 5 that you've discussed here today. Were you ever asked to compare the DNA profile with the DNA profiles of either Brian Higgins or Brian Albert?
I was not.
And your answer was you were not?
I was not.
Did anybody ever provide you with DNA profiles of Brian Higgins or Brian Albert?
Sustained to that.
I may have one moment, Judge.
Yes.
No, not if it's going to be used to make a giant conspiracy about 72 other people whose DNA wasn't taken, whose DNA wouldn't have been taken because they committed no crime. Right?
I just have one more question for you, Mr. Porto, and I do want to thank you for answering all my questions here today. You wrote reports on your analysis of all the items and the work that you did on this case?
I did.
And you are directed pursuant to protocol to address those reports to somebody, correct?
Correct.
Who was it that you sent the reports to in this case?
I'm sustaining the objection.
Did you send those reports to Michael Proctor?
Sustain. Jurors, strike the question.
I have nothing further. Thank you, sir.
He just want to sneak that in there. That he knew it was going to be objected to. Playing games per usual. I'm taking notes. Does that count? I also have a headache though, so I just took Tylenol, which is like adds.
Porto, based on your training and experience and years of doing DNA testing at the lab, when it comes to samples from items of clothing, is it uncommon or common to have multiple contributors?
That depends. It can happen, but it's possible, yes.
Is it something that's a complete anomaly?
I wouldn't say so, no.
Now, turning your attention back to item 3-1.1, that's the sample from the passenger side taillight of the defendant's vehicle, correct?
Correct.
And Mr. O'Keefe was found to, his known DNA profile was found to be an inclusion for the DNA profile from the swab from the defendant's passenger side taillight, correct?
He was included in the profile, yes.
And to what statistical, what is the number associated with that inclusion?
The DNA profile from this item is 510 non-alien times more likely to have it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals.
Now, Mr. Porter, if I could turn you back to number 10 in your report, there's a number of different items listed there, correct?
Correct.
And as far as the items listed associated with various stains on various areas of Mr. O'Keefe's orange t-shirt and gray long sleeve shirt, there's about 13 different DNA profiles that you generated in reference to those items, correct?
Correct.
And from those 13 different items, they're all from a single contributor. Is that correct?
Correct. They were interpreted as originated from a single contributor.
And as far as the DNA profile, your comparison of each of those 13 different stains on the orange t-shirt and the gray long sleeve shirt, what were your conclusions again as your comparison with the known standard of John O'Keefe?
Yeah, so the profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And lastly, with reference to the fingernail clippings from both the right hand and the left hand of Mr. O'Keefe, those were also, your analysis provided for inclusion of Mr. O'Keefe's known DNA standard, correct?
You're still missing good questions.
He was included in the profile, correct.
And
Could it have
again,
been?
the profile from both the right hand and the left hand fingernail clippings was a single source contributor, correct?
Sustain.
How many sources were associated with those?
Sustain.
What?
Nothing further.
Okay. You all set, Mr. Unetti?
Yes, Your Honor, thank you.
You are all set, Mr. Porto.
Thank you.
Very much.
See, this is where like I give Lally the critique. You should have asked if those contributors could have been
Ashley Valier to stand.
medical staff, Karen herself and Carrie when they found him, anybody from the restaurant or the bars they were in. Like that's, you know what I'm saying? Like those are missed opportunities when it comes to Lally. And this is why I have criticisms of him. Those should have been, that's like lawyering 101. Like, come on, dude. No, he's excluded from the Order, Ash. Be in court and be a witness, just like Mrs. O'Keefe.
I do.
They were excluded from the sequestration order because they're the family. Oh, this lady, I remember her from last trial. Ashley Valier.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, Ms. Lear.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Ash Valier, spelled Vallier.
And where do you work?
I work at the Massachusetts State Police Crime Laboratory.
And where did you go to school?
I got my bachelor degree in biochemistry and cell biology from UC San Diego and a master's degree in biomedical forensic sciences from Boston University.
Now, following your education, where did you go to work from there?
Directly after I got my degree at Boston University, I worked at the Broad Institute.
And what did you do at the Broad Institute?
I did quality control checks of items that potentially could be tested for pharmaceutical use.
Now, how long have you worked at the Massachusetts State Police Crime Laboratory?
A little over 6 years.
Now, is the state lab accredited?
It is.
And by whom?
ANAB.
And what does ANAB stand for?
It stands for ANSI National Accreditation Board.
And the ANSI within the ANAB, what does that stand for?
That is another acronym that I don't recall right now.
Now, as part of that accreditation process, do you undergo any sort of type of proficiency testing?
I do.
And can you explain to the jury what that proficiency testing process consists of?
A proficiency test is a test that is
She was like this last time
given
too.
from an outside agency in the discipline that you do casework in.
I do.
That you work through like a normal case,
was
but
the
it has
first
an end expected result at the end.
And how often do you undergo proficiency testing?
Every year.
And what areas do you specifically undergo proficiency testing in?
I've done proficiency tests in gunshot primer residue and physical match analysis.
And have you successfully completed each of those proficiency tests that you've taken?
I have.
Now, when you initially joined the State Police Lab, what was your position and title that you were hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury what your duties and responsibilities were as a forensic scientist 1?
So a forensic scientist 1 is the introductory level. It's when you start your training in whatever discipline you're going to be trained in and quality control checks. After you've been at the laboratory for over a year and you're signed off to do casework, you become a forensic scientist 2.
And you're currently a forensic scientist 2, is that correct?
Yes.
What is the difference between a forensic scientist 1 and a forensic scientist 2 at the Massachusetts State Police Crime Laboratory?
Just said introductory.
A forensic scientist 2 has been at the lab for over a year and can do casework.
Now, just in general terms, what does the trace unit do or examine within the State Police Crime Laboratory?
I'm a part of the trace arson and explosives unit. So we analyze a wide range of pieces of evidence. So trace covers a lot of small things. So paint, fibers, glass, gunshot primer residue, physical matches. Arson covers fire debris evidence, and explosives covers explosives.
Now, specifically with reference to physical match analysis, can you explain to the jury, just in general terms at first, how is that analysis performed?
She might be.
So physical match analysis is piecing broken things together to see if they were at once a single item. Generally, you look at the questioned item first, the item that you don't know specifically where it came from.
Yuri was like 28.
Look at that. And then you would look at the known item, which is an item with a known source, like specifically like this window or like this vehicle.
Yuri was witness number 24.
They're analyzed at separate times. And then if it looks like there could potentially be a physical match, you would analyze them together and see if they have a mechanical fit.
Now, when you retrieve items just in general to do some sort of physical match analysis, where do you get those items from?
we have evidence storage locations at the laboratory.
And how are they typically packaged when you receive them?
They can be packaged in cardboard boxes, brown paper bags, heat sealed plastic bags. It depends on the individual items.
I just counted where
And
like it definitely.
when you're doing this
30-something,
analysis
40.
as far as the physical match analysis, what
He
do
was
you
24.
do to your bench between your examination of separately packaged items?
Kaylee was 25.
I mean, before I do any analysis, I bleach my bench,
Brent
clean my
was
tools,
26.
and then put down a fresh sheet of butcher paper
And why do you do
Gallerini
that?
27.
to make sure everything's clean.
Now, again, speaking more in general terms, on what types of evidence can you perform a physical match analysis?
Sorry, can you repeat the question?
Sure. In general terms, with your work within the lab, on what types of items can you perform a physical match analysis?
A lot. Anything that has a broken or irregular edge.
Dirty
Would that
something.
include glass?
Yes.
Would that include plastic?
Yes.
What are some of the other things that would also include?
Any sort of like polymer, metals.
And when you're doing a physical match analysis, what instruments do you utilize in the course of that analysis?
Notes.
Generally, I'll use a stereo zoom microscope. Depending on the size of the items compared, I can use other microscopes as well.
Now, what is a stereo zoom microscope?
Stereo zoom microscope is a microscope that's mounted on a stand. So it gives a wider range of view that you can look at larger items.
And how are you using that specifically in your physical match analysis of, let's say, items of plastic?
I'll use it to look at the edges and see if there's any like defining characteristics along those broken edges.
Now, as you're going through your analysis, do you document your work as you go?
I do.
And how do you do that?
With handwritten notes and with photos.
Now, at some point, were you assigned to perform some work on lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes.
And what type of work were you assigned to do in this case?
I was asked to do a physical match analysis, and then later on I was asked to look at, do some trace recovery, look at some debris.
Starting with the physical match analysis, how many different items approximately were you asked to look at?
Over 10.
Several, fair
About,
to say?
Yes.
Okay.
depending on how many they're
How
actually
are
going to.
each of those items packaged when you receive them?
So the questioned items were packaged first in a large paper bag, and then each item was individually packaged in a smaller brown paper bag within that container.
Now, again, just in general terms, because you've used it a couple times. When you say questioned item versus known item, as it pertains to this analysis in this case, what were the questioned items generally, and what was the known item?
The question items were items labeled as coming from a road, and the known item was labeled as coming from a taillight from a vehicle.
Now, in this case, did you perform your physical match analysis in the same manner that you've previously described based on your education, training, and experience within the lab?
Yes.
Now, initially, you had examined some various plastic and glass items, and there was a drinking straw in there as well, correct?
Yes.
And specifically, as far as the item numbers that you looked at in this physical match analysis, could you provide the jury with the list of just the item numbers first to start with?
May
Your
I?
Honor.
You have your report with you, Ms. Willett?
I do.
Is there any objection to me using the report?
No objection at all.
So feel free to use it.
Thank you, Your Honor.
So the questioned items labeled as coming from the road were item 7-5, item 7-6, 7-8, 7-9, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, 7-16, and 7-19. And the known item labeled coming from the passenger side taillight is item 3-1.
Now, Ms. Valier, within those specific item numbers of how things are labeled at your lab,
I would say so.
if there are different pieces associated with the same item, how is it that you
3
label
days
those
last
specifically
time.
in this physical match analysis here?
So some of the items had multiple pieces within that item. So I labeled them A, B, C, etc., depending on how many pieces there were.
Now, if you could, please explain to the jury just, again, the process that you followed in your examination of each of those items.
So first I looked at the questioned items, the items labeled as coming from the road. I looked at, I documented the overall package because they were all packaged in the same container, the same brown paper bag. Documented that individually. Inside of it, there were a bunch of individual brown paper bags. Documented that, and I went one at a time through them, opening each paper bag, taking written notes, taking photos of the items inside. Within each item, I looked to see if any of those pieces fit together. And I cleaned my bench in between the items.
Your Honor, may I approach?
Yes.
And Your Honor, so quotes, I've shown this to Yannetti all these photos in advance.
Okay.
Right? She could put it back
Objections to
together.
Any of them, Mr. Mayor?
Objection, Your Honor.
All right, so why don't we just go ahead and mark them all as evidence?
They're just benching Jackson at this point.
Okay.
I find this interesting. We haven't seen Jackson in like 2 days.
Ms.
They're
Valier,
just
I'm showing
benching
you
him.
4 photographs. You recognize those?
I would. He needs to be benched, to be fair.
I do.
What do you recognize those to be?
These are photos that I took of item 3-1.
Again, what was the description associated with item 3-1?
Passenger side taillight.
There you
Does
are.
that description further give sort of a specific vehicle or license plate associated with the vehicle that the taillight came?
It does. Massachusetts 3GC684.
Your Honor, the Commonwealth will seek to introduce in a minute the next exhibit A through D.
Right,
Still
those
haven't
are-
seen Potluck or Grave yet this morning.
Mark them all because they're all coming.
Couple other people.
If the court prefers, I can provide them.
Exhibits 178 through 178.
I always notice when you guys aren't here. I worry till you
May I
pop
approach
in.
with the remainder, Your Honor?
Yes. If you have
Like a
the
mom
rest-
worrying about all her children's.
This way, I'm showing you 2 more photographs. Just ask if you recognize those.
I do.
And what do you recognize those?
Photos I took of item 7-5.
And again, from your report, what was the
That's right.
description in reference to item 7?
Lovely.
Yeah.
Thank you. You're fine. It's just that.
Okay. Piece of plastic red recovered from 34 Fairview Road.
You're on the Commonwealth seek to introduce in a minute the next exhibit A and B.
Okay.
Exhibit 171 A and B.
My apologies, Your Honor. With the court's permission, may I publish some of those?
Yes.
photos to the jury? Ms. Gilman, if I could first ask for photograph 2122. And Ms. Blair, what's up on the screen? That is the bag associated with the passenger side taillight or the known item, correct?
Correct.
And Ms. Gilman, if I could have photograph 2125. And Ms. Gilman, if you could just enlarge a little bit towards the bottom where the ruler is. Now, Ms. Valier, what's up on the screen now as far as the sort of notations there? Who made those?
I did.
And how do you know that you were the one who made those?
That's my handwriting, and those are my initials.
So the AMV is for your name, correct?
Yes.
And with respect to each of the items that you photographed, you had photographs that were taken of sort of what was in the evidence bag in total displayed on your table that you would clean with the solution and everything else, correct?
Yes.
And Ms. Gilman, if you could just zoom out a little bit to show the item. And again, what's up on the screen, that is item 3-1, the known item as far as the tail light from the defendant's vehicle.
Yes.
And Ms. Gilman, if I could have 2126. And Ms. Lear, if you could just describe for the jury, what are we looking at in this photograph?
Those are the same items, just turned over.
And lastly, for this set, Ms. Gilman, if I could have 2135. And again, same item as far as 3-1, the tail light taken from the defendant's vehicle.
Yes.
Ms. Gilman, if I could ask for photograph 1905. And Ms. Lear, as far as with each of these items, you take photographs when they're inside the bag and then once you take them out of the bag, correct?
Yes.
Okay. And Ms. Gilman, if I could have photograph 1908. And what are we looking at in this photograph?
The contents of item 7-5.
May I approach again, Your Honor?
Yes.
We'll need 2 more photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-6.
That's one of the bag and then one when the item is taken out of the bag. Is that correct?
Yes.
And what was the description for item 7-6?
Piece of plastic, clear, recovered from 34 Fairview Road.
I appreciate those. I'll call them up to seek to introduce in the minutes the next exhibit, A and B.
172 A and B.
With the court's permission, may I publish those to the jury?
Yes.
Ms. Gilman, if I could have photograph 1921. And then photograph 1924. And what's depicted up on the screen is that what you just have before you as the photograph that you took of item 7-6 recovered from 34 Fairview Road.
Yes.
Thank you. May I approach the witness again, Your Honor?
Yes.
Other photographs, review those. Do you recognize those?
I do.
What do you recognize as?
Photos I took of item 7-8.
And one of the bag and then one of the items removed from the bag, is that correct?
Yes.
And what is the description associated with item 7-8?
Piece of plastic, red and clear, recovered from 34 Fairview Road.
Almost seek to introduce in the minutes the next exhibit, A and B. And Your Honor, with the court's permission, if I could publish those to the jury.
Yes.
Exhibits 173 A and B.
Ms. Gilman, if I could have photograph 1931 and then 1934. And Ms. Gilman, if you could zoom in just a little on those items, please. And Ms. Lear, again, what are we looking at in this photograph of item 7-? What are we looking at again in this photograph? Excuse me.
Photos of item 7-8.
May I approach the witness again, Your Honor?
Yes.
Two other photographs. Those. And do you recognize those?
I do.
What do you recognize those?
Photos of item 7-9 and 7-19.
And as far as the first photograph, as far as the bag, and then second with the items taken out of the bag, is that correct?
Yes.
So 7-9 and 7-19 were contained in the same bag.
They were. I then separated them into 2 separate packages.
And as far as 7-9 and 7-19, respectively, if you could tell the jury what was the description for each of those items.
Item 7-9 was pieces of glass recovered from 34 Fairview Road. Item 7-19 is trace item black straw recovered from 34 Fairview Road.
Your Honor, will seek to introduce in the minutes the next exhibit, A and B. May I publish, Your Honor?
Hold on.
Oh, forgive me.
74A and 174B.
Now you can publish.
My apologies. Ms. Gilman, if I could have 1958, please. And then 1962. And again, Ms. Lear, what are we looking at in this photograph?
The contents of that bag, item 7-9 and item 7-19.
May I approach again, Your Honor?
Yes.
Two other photographs, do you recognize those?
I do.
And what do you recognize as?
Photos of item 7-10.
And again, one of the bag and one of the contents of the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description for item 7-10.
A piece of plastic, red, recovered from 34 Fairview Road.
I'm going to seek to introduce in a minute the next exhibit, A and B.
Exhibits 175A and B.
May I publish that for the jury, Your Honor?
Yes.
Ms.
I mean, the
Gilman,
court's
if I
been
could
told,
have,
so why they haven't
152.
done anything is beyond me.
And 1956. And again, Ms. Lear, what are we looking at in this photograph?
Photo of item 7-10.
Thank you. Gilman, you can take that down. May I approach the witness, Your Honor?
Yes.
Two other photographs, do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-11.
And again, one photo of the bag and one photo of the items outside of the bag.
Yes.
And again, if you could, please tell the jury what the description is associated with item 7-11.
Piece of plastic, 6, red, clear, and black, recovered from 34 Fairview Road.
The call to seek to introduce and admit as the next exhibit, A and B.
Exhibits 176A and B.
And may I publish, Your Honor?
Yes.
Ms. Gilman, 1979 and 1982. Again, Ms. Lear, I'm sorry, Ms. Gilman, if you could zoom in just a little on the items themselves. And Ms. Lear, what are we looking at in this photograph?
Photo of item 7-11.
These are photos, again, that you took in the lab during the course of your comparative or physical match analysis, correct?
Yes.
May I approach again, Your Honor?
Yes.
Two other photos, you could look at those. Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-12.
And again, photograph of the bag, photograph of the items outside of the bag.
Yes.
If you could, please tell the jury what's the description of item 7-12.
Trace item, 14 glass and clear plastic, recovered from 34 Fairview Road.
Now, the call to seek to introduce in minutes the next
Okay.
exhibit, A and B.
Exhibits 177A and 177B.
Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 2015 and 2018. And again, Ms. Gilman, if you could just zoom in a little on the items. Thank you. And Ms. Lear, again, can you describe what's depicted up on the screen?
A photo I took of item 7-12.
Your Honor, may I approach?
Yes.
Two other photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-13.
And again, one of the bag and then one with the items removed from the bag.
Yes.
And if you could, please tell the jury what is the description for item 7-13.
Piece of plastic, red and black, recovered from 34 Fairview Road.
I'll let the seat introduce the next exhibit A and B.
Exhibit 178A and 178B.
Your Honor, may I publish?
Yes.
Ms. Gilman, 1997. And 2000. And again, Ms. Gilman, if you could, please zoom in on the items. Thank you. And Ms. Valier, directing your attention to the screen, can you describe for the jury what is depicted on the screen now?
A photo I took of item 7-13.
May I approach the witness, Your Honor?
Yes.
And two other photos. Do you recognize those?
I do.
What do you recognize that?
Photos I took of item 7-14.
And again, one of the bag and one of the items removed from the bag.
Yes.
And again, can you please tell the jury what the description is associated with item 7-14?
Pieces of glass recovered from 34 Fairview Road.
I want to seek to introduce the next exhibit, A and B.
Exhibits 179A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2009 and 2012. And again, Ms. Gilman, if you could zoom in on the item. And Ms. Valier, as far as what's depicted on the screen, again, if you could describe for the jury what that is.
A photo of item 7-14.
May I approach the witness again, Your Honor?
Yes.
Other photographs, if you could recognize those.
I do.
And what do you recognize as?
Photos of item 7-15.
And again, one of the bag and one of the items taken from the bag, correct?
Yes.
And if you could, please tell the jury what is the description associated with item 7-15.
Piece of plastic, 3 clear and 5 red, recovered from 34 Fairview Road.
The problem we'll seek to introduce in a minute as the next exhibit, A and B.
180A and 180B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2072.
Yes.
Yes.
And 2077, please. Again, if you could zoom just a little as far as the items are concerned. And Ms. Valier, what are we looking at in this photograph?
Item 7-15.
Which is?
May I approach again, Your Honor?
Yes.
Other photographs, do you recognize that?
I do.
What do you recognize that?
Photos I took of item 7-16.
And again, one of the bag and then one of the contents from the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description associated with item 7-16.
Piece of plastic, red and clear, recovered from 34 Fairview Road.
I'm also seeking to introduce the minutes of the next exhibit.
Exhibit 181A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2036 and 2040. And Ms. Gilman, if you could zoom in just a little. Thank you very much. And Mr. Lear, if you could, please describe for the jury what we're looking at in this particular photograph.
This is item 7-16.
Ms. Gilman, you can take that down.
Morning, Jack. Choose the tail light. Yes.
With respect to each of these items that you examined in your physical match analysis, again, as far as the process is concerned, with the questioned items, what are you doing with reference to each of those questioned items first?
First, I document them as you've seen. I'll see if any of those within the item have a physical match with each other. And then I'll package that away and look at all the questioned items before I compare inter-questioned items to see if there are any physical matches in between all of the 7- items.
And as far as your notes are concerned, what is it that you're noting in reference to each of those items as far as what characteristics of the item are you taking note of?
I'll note the size, the color, and the material.
And what, if any, measurements do you take of each of those respective items as well?
I'll take the length and width of each item.
Now, with respect, starting with item 3-1, the passenger side taillight from the defendant's vehicle, sort of internally within that item 3-1, what did you conclude as far as your physical match analysis within that item alone?
Within item 3-1, I believe 4 of the pieces fit together.
And Your Honor, if the witness may refer to her notes
Yes.
as to, thank you.
Yes, four of the pieces fit together within item 3-1.
And which 4 of the pieces?
Pieces A, B, D, and F.
And as far as the labeling of those pieces of an individual item, let's just start with item 3-1. A, B, D, and F, how are they labeled and how do you sort of physically label those items?
We have a label maker in the lab, so I'll print out the case number, the item number, and then A, B, C, and my initials, and that goes physically on each of those items, or all of those pieces.
So if any of those items had a sticker on it with a letter or something associated with that, that would be something that you did during the course of your physical match analysis, correct?
Yes.
Now, if I could turn your attention to item 7-5, piece of plastic red recovered from 34 Fairview Road. What did you conclude as far as your physical match analysis just within that single item?
There was no physical match noted among those 3 pieces of apparent plastic.
And when you say no physical match found from the different pieces within that item, what does that mean?
The broken edges of each piece did not align.
So the broken edges of the individual pieces within item 7-5 did not fit together with the broken edges of pieces within item 7-5, correct?
Yes.
Okay. Now, with respect to item 7-6, a clear piece of plastic recovered from 34 Fairview Road. What did you conclude based on your physical match analysis just pertaining to that item 7-6?
So this item was 2 pieces of colorless apparent plastic, and there was no physical match noted between those two pieces.
Now, with reference to item 7-8, red and clear plastic recovered from 34 Fairview Road, what did you conclude in regard to your physical match analysis just with the pieces contained within item 7-8?
So there were 14 pieces. Pieces C and D fit together, and pieces E and F fit together.
And when you say fit together, is there a term of art used within your field called a mechanical fit?
Yes.
And can you explain to the jury what you understand that term to mean as far as what is a mechanical fit?
So a mechanical fit and a physical match are the same thing. It's when the broken edges align together to show that they were once a single item.
Now, if I could turn your attention to item 7-9, pieces of glass recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis of just the individual pieces contained within item 7-9?
So this item had 3 pieces and no physical match was found between those.
Turning your attention to item 7-10, red pieces of plastic recovered from 34 Fairview Road. What were you able, that is a single item, is that correct?
Correct.
So no physical match because there's nothing to match, it's just one piece, correct?
Correct.
And turning your attention to item 7-11, identified as 6 red, clear, and black pieces of plastic recovered from 34 Fairview Road. What did you conclude in regard to your physical match analysis just within those pieces contained within 7-11?
So that item had 6 pieces and there was no physical match noted among those 6.
Now, turning your attention to item 7-12, which was identified as 14 pieces of glass and clear plastic recovered from 34 Fairview Road. Again, what did you conclude from your physical match analysis just from the various pieces contained within item 7-12?
So there were 14 pieces overall. Pieces B, C, D, F, and K fit together mechanically as one unit. And then pieces E and I fit together mechanically as one unit. And pieces M and N fit together mechanically as one unit.
Now, through your examination of these pieces in particular and other pieces as well, did you note any debris contained on the pieces that you located?
Yes.
And can you say anything as far as what that debris was, or was there any analysis done of that debris specifically?
I just note that there was debris present and I package it into a tin that's retained with the original packaging.
Now, turning your attention to item 7-13, that was a piece of plastic, red and black, recovered from 34 Fairview Road. Is that correct?
Yes.
And again, just with respect to your physical match analysis of the various pieces of 7-13, what did you conclude?
So that item had 3 pieces and there was no physical match noted among those 3.
And again, with reference to item 7-14, piece of glass recovered from 34 Fairview Road, that was again a single item, correct?
A single piece, yes.
So I'll turn your attention to item 7-15, 3 clear and 5 red pieces of plastic recovered from 34 Fairview Road. Is that correct?
Yes.
And what were you able to conclude from your physical match analysis, again, just from the various pieces contained within item 7-15?
So there were 8 pieces in this one. Pieces F and H fit together mechanically.
Turning your attention to, lastly, for this purpose, item 7-16, a piece of plastic, red and clear, recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis just contained within the pieces of that single item, 7-16?
So that item had 7 pieces. Pieces A, C, and D fit together mechanically.
Now, Ms. Valier, once you had examined each of those pieces individually, what did you do next in your analysis?
Next, I compared all of the inter-questioned, these items 7-5 to 7-16. I compared them to see if there was a mechanical fit amongst those, between those items.
Mr. Lally, is this a good place for our break?
That's perfect. Yes, Ron.
All right, jurors, we'll take our morning break. We'll see you back here in about 15, 20 minutes. Thanks for you can walk out right with the jurors. And can I see counsel for a minute, please?
Oh, for fuck's sake. This technically counts as a sidebar. She's saying she wants to see counsel. I want to see if she's going to do it. She didn't say it's sidebar. She did say she wanted to see counsel. While we're waiting, can we do us a favor? Hit the like button, hit the subscribe button. We definitely could use your help. Hit the share button. Share our videos with people who don't know we exist yet. Let's try to get our first donation of the day. It's Friday. It's a very slow day for the channel in general. Don't ask me why. You would think Friday would be like a better day. For some reason, it's just a very slow day for the channel. Let's change that today. I could definitely use that help. I got a $150 bill out of nowhere that I need to pay. That was not expected in my budget. That's for sure. Yeah, I can't. I'll say things here and there, but I can't. If you stop constantly for the commentary, then like you never get the trial done. You know what I mean? Like you'll be here for 3 more days after the trial ends. It's already a long day. So I don't pause. If I have to say something, I'll say it real quick or I'll wait for a break. You know? They do it too much. That's for sure. Have a good day, Sherry. Yeah, I mean, that's why we're kind of here, Jack. You know, like, I think what bothers me most about the mainstream media is I can't say they're getting the same information I'm getting. Obviously, I get it faster than they do. I have sources, you know, in all different sorts of places because I worked in the criminal justice system. So I have sources sort of like everywhere in all different sorts of places. You know what I mean? Not just the court systems or the court, like jails and medical people, like all sorts of people who give great information and opinions, like, you know. And so for me, I know that the mainstream media gets the information as well. I don't know if they're getting it as fast as I get it, but they get it, right? Whether it's, I'll find sometimes it's like a day or two ahead of them. Either way, they have the information, some information they get before we do, yet they don't report on it. They sit on it and sit on it and sit on it and sit on it until something happens. And then they act as if they just found out that minute. Most of the time, they just don't say anything. They go with what's the popular narrative or what they think the popular narrative is, because it's all about ratings, folks. Ratings. That's what it's about for them. And I unfortunately can't say this, that it's not also for creators. I mean, most creators want more viewers. That's kind of how you grow your channel. But I'm not willing to sit here and lie to get them. Kevin put it so eloquently in his sort of comeback stream last night, where he explained to his audience basically what he went through, which is the exact same thing I went through once I decided I was going to speak up against the mob, which is that in 1 minute, you lose 95%, probably a couple hours, you're 95% of your subscribers and 100% of your income stream that's coming in. It dries up just like that when you're willing to go against the grain. But that's where the evidence took me, period. There is no, oh, well, you know, I could have done what a lot of these other people do, which is just keep saying over and over something that I don't believe to be true, and just ignore evidence that's coming in for donations to keep rolling in. And it took Kevin a while to sort of build his channel back up. You know, like it goes from being a steady to just a catapult downwards immediately once you're willing to stand up and say something. And it's the exact same thing I went through, except I took a 6-month break.
All right, Mr. Leslie, I'll hear you.
With my daughter's
You
health
are
and
unmuted.
So, you know, Kevin's got like 15,000, I think, or a little more than that. I'm not there yet because I took that break. So, you know, I'm still trying.
Thank you, Your Honor. Yesterday, Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess, that the defense received on May 11. And what I wanted to do, Your Honor, is briefly provide the information Your Honor asked for yesterday, which was how much time we might need under various circumstances. And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so.
No, please.
So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue.
Oh, please.
And so with regard to the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need. I again urge the court to reject it substantively.
The judges,
because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with regard to observing a vehicle at 12:45 a.m. We, and that's a significant point. I know I don't need to elucidate for Your Honor. It goes, all of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. It just never, no collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today.
Please don't elucidate
it.
The
jurors have been provided information, and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is on May 11th,
your claim is based on timing?
Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we crossed, we strategized with regard to, but also my decision to not even cross Trooper Garino, because Trooper Garino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that.
That's the computer data.
We have Mr. Whiffen, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had. And I cross-examined Mr. Whiffen extensively with regard to that timeline. There were several defense strategies and effectuations of strategies based upon that timing. So with regard to the substance, Your Honor, and there's more, but I think that's a fair representation. It innervates our entire defense. The question now of Your Honor of how much will the Commonwealth made take the defense about your Rule 14 to react violation to Mr. Burgess. I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation in terms of cross-examination. So we would have to, and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared that are based upon that timeline. So it is a very significant point. And to the extent that the Commonwealth tries to argue, well, you know, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range, 1238 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked yesterday. Again, I urge that it just be rejected and we keep this trial moving in its current pace. To the
That's what the
extent that
Commonwealth
that
said
does
about
not occur, and
Erica.
again, we urge that it be rejected, the
No,
report,
please.
because it's a Rule 14 violation.
Yours was a
There
rule
is
for
no remedy
multiple.
for the defense.
what
However,
Commonwealth
to the
said.
extent, and given your honor, nonetheless asked me for an answer in time,
Correct.
we would need 4 days to be able to address it. We will not ever be able to recover strategically or substantively.
Neither will the
from it,
Commonwealth,
given
sir.
all that's been presented to the
With
jury.
your ARCA
And
bullshit.
it will be very difficult to figure out how we're going to go present a defense after we've already
The
presented
hypocrisy
to the jury
is amazing.
our
Same argument the Commonwealth
defense
made.
in our cross-examination.
Just
It's
saying.
not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them and eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as ARCA, but DeSogra and Gaffney and other types of witnesses that we have in that regard. So my, Your Honor, respectfully, that is my response.
That your argument's the same?
Yeah.
Yes, the Commonwealth does want to be heard.
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact would be. This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided. The Commonwealth has always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welch's PowerPoint presentation where it shows that time, 12/31/43, has never changed. Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believe that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked at the variance at the time of a 3-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the telestream and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody.
9 law school students can't do it.
Text message where she
Come on.
said she thought she saw a motor vehicle out front that evening at 12:45. That is not consistent with the Commonwealth timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorga. So because this is inconvenient for the defense, and because it further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their expert's mistake about that variance. There's nothing new here. Nothing has changed.
Get it, Hank.
Go right ahead, Mr. Leslie. The only
No.
question I had for you yesterday, for you to respond to today was the time, so I gave you more leeway.
That's it.
You're giving me more leeway, and I appreciate it.
Go right ahead.
So 2 items, Your Honor. As I alluded to yesterday, and it's been a point that Mr. Brennan just made. We believe strongly, Your Honor, that at a minimum, there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline. In his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report, is anchoring in his timeline.
Reports based on evidence and data, you dumbass.
Conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire, Mr. Brennan yesterday said, we were surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did.
Why would that
Lastly, Your Honor, with regard to
sit down. Sit the book down. Sit.
Mr. Brennan's point, he made it yesterday and I corrected it. He said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this.
And the defense,
now Mr. Burgess
therefore,
is changing what
wrong.
he is saying.
No,
so
he's not.
It is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done.
Take several seats.
Is this. There was also an issue, Your Honor, and this is extremely important with regard to
everybody looking around.
shifting.
Like, shut the fuck up.
There's not only the question of should this be allowed at all, there's not only the question of how much time the defense will need, but there's a third and important issue.
It is. That's all she asked.
What Mr. Brennan proposed yesterday,
the burden's already been shifted.
A very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance.
No,
so what
he's
the
not
Commonwealth
changing.
is proposing is
narrowing.
that
there's a difference.
our witnesses go forward. The aperture gets to wait. They come on, and then they get to come. The aperture gets to come on yet again
because of your bullshit.
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr. Brennan?
I appreciate the clarification.
I'm not sure what he's saying. So
it sounds like DeBrosia or whatever.
His name
Not sure what he's saying.
DeSoder. You're suggesting that the Commonwealth suggested yesterday that he testifies first and then the aperture witnesses?
What I understood was going to happen is
not what he said.
Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st, or whatever the date was.
Yep.
And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for.
Correct.
Not that they were holding back Dr. Welcher completely. Is that correct? Mr. Brennan?
Correct.
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So just so I'm clear, what is it?
Because you're an
that
idiot.
the
Mr.
rebuttal-
Brennan, all right, this is separate, and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Regarding Mr. Burgess or Mr. Welcher?
Which, Dr. Welcher?
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which address all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments, Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal, address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how I did also.
Idiot.
The question is now with the Burgess.
He said, I don't even know what
change
he's
to the
saying.
doctrine, how many times is the Commonwealth proposing that Dr. Welcher gets to come in?
Thank you, JMS. I appreciate
Just
you.
going to come in and talk about it.
So you talk with Mr. Brennan about that. All right, so I'm all set for this.
There are no
So what is she-
changes. There is no changes in the timeline. He keeps trying to portray this as something has
Yes.
changed.
No.
Nothing has changed. It's the exact same. He's always said there's a variance. He's been looking into the variance for a long time. And now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the
Correct.
reports. It's all the same, always has been. Other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever.
None as
Does the
usual.
Commonwealth oppose a voir dire just on that one issue?
Yes.
Yes, because it's suggesting that there's a good faith
Something
basis
new.
for it. Nothing has. Ian Whiffin's report was available to the defense and our experts
Forever.
months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They
Yes.
cannot point to one thing that has changed between Dr. Welcher, Ian Whiffin, Jessica Hyde, or Shannon Burgess. They
Nope.
are just saying things without a good faith basis.
Yep.
In the report, show us where something has changed.
Your Honor, to
Yes.
inform you, Your Honor, we would like to print the page in the clock adjustment because what Mr.
So,
Brennan says is.
yes,
correct.
and I'm happy to any information.
Thank you.
All right.
Change.
It's not an adjustment. It's refining it within seconds.
you.
All right, to the court, please.
The argument he's making not only is contrary to what the fuck is actually happening, because that's not what's actually happening, and he's completely confused and has clearly, per usual, no idea what the hell he's actually talking about. Okay, but we're talking about him sort of. He's literally complaining that because his experts didn't give shit until the 8th or 7th, whatever day it was, that the Commonwealth now gets to sort of look at it and like refine more what the expert is talking about. And the Commonwealth's expert has now found a method to sort of refine the clocks to match up each other, even though they're not the same times because they're different. Like my phone might have a different clock than my computer, and my computer might be 7 seconds ahead of my phone. That doesn't mean it's not. So if I have a crash right this second, the computer might say it's 7 seconds ahead of what my phone says, but it's still at the exact same time. Do you guys understand how I'm explaining it? All they're doing is refining the seconds of trying to match up. Well, the phone says 7 seconds. So at 12:07, I'm just using it as an example, at 12 a.m. 07, the computer says a crash happened. And at 12 a.m. 01, the phone says it happened, but it still happened at the exact same time because the two clocks aren't synced up to the second. So that's not changing anything. The time is still there. The time he took his seatbelt off, still there. Time Karen's car backed up, still there. The time his phone stopped moving, still there. Like, we're talking about seconds here. Like, you know what I'm saying? Like, then he wants to sit there and argue that that, oh, they would be burdened and the burden would shift to the defense. The burden has been shifted, even though the Commonwealth bears the burden, it has been shifted onto them 3 times more than it normally is supposed to be, just alone by allowing ARCA to do stuff this late into a trial, okay, with their reports, because then the experts of the Commonwealth have to rush to rebut the BS that ARCA brings in, okay? And so there has to be a remedy for that for the Commonwealth. The remedy should have been exclusion. Should have been. But since the judge didn't exclude ARCA, the only other remedy left available for the Commonwealth is to allow that expert to go after all the ARCA stuff after ARCA testifies and rebut it, because it gives them more time throughout the trial while the defense is putting their case on to continue doing their job of going over it. ARCA needed a month. You think it's going to take the Commonwealth's expert a month? Like, you know what I'm saying? So that's the only remedy that would be available to the Commonwealth other than excluding ARCA again. So the defense comes in and actually tries to argue the exact same thing the Commonwealth argued before about the burden and about the only remedy being exclusion. You're arguing against yourself, you idiots. Like, what? The fact they're even arguing this is amazing to me over seconds. Nothing's changed. So to claim it has is disingenuous at best. You know? Yeah, let's read that now, JMS. I appreciate you. I could definitely use the extra help with that unexpected bill that I got today. So let me check now on my email for PayPal. I did put the link, the regular link for just the, if you don't have payment apps like, you know, PayPal, or you don't have to have PayPal, you don't have to have Venmo or Cash App or Revolut or any of those. There is a link specifically, this one, it's in the chat. It does say PayPal, but you don't have to have a PayPal. You just click on it, put any amount you want, and you can use credit or debit, because a lot of you don't have some of these payment apps. You ask, you shall receive. It definitely helps the channel too. So I appreciate it. It is in the chat. I can always put it in there again. And JMS makes the first one of today. So it's $25 donation. The first one we get today. Thank you, JMS. I appreciate you very, very much. Fridays are extremely slow for whatever reason for the channel. And it's been a struggle. These 8-hour streams cost me. They don't, you know what I'm saying? They cost me a lot more than what a regular 3 or 4 hour stream I do with you guys normally does. So I don't even normally break $100 on a 8-hour stream like this because they're so long with the trial. So any and all help is well appreciated because I don't have monetization yet. And as you guys know, YouTube is extremely slow when it comes to doing any of this BS. Like, that's what they're trying to do, Avi, is the catastrophic, it'll be so catastrophic for the defense, which is just a false statement. It's all the same. There's nothing catastrophic about refining seconds that are already there. The timeline's already there. Like, it's nothing that changes about it. So I think that's why Hank was like, once again, they're saying things with no good faith basis. They're just saying it to, like, and once again, as we know, it's to rile the mob, right? Get the mob to sort of run their mouths and hit talking points and spread it around to every and all other people, which is just crazy to me. Like, they are like toddlers, like stomping their feet. You know, it's like when my kids were little. You're so mean. Whack. You're so mean. I can't do this. Like, that's what the defense just did. Like, that's literally what they just did. Nothing really other than Alessi whining. Like, other than him whining. Like, I don't think Alessi's ever done a trial before. If he has, he is not showing it, and he needed to take several seats with that argument. It's the most ridiculous. And the judge reminds him, like, the only question, Mr. Alessi, I asked you is how long would it take you? How many days would it take you to go over the information? How many, rebut it? How many? How many? That's all she asked him. She already had her mind made up. This wasn't about whether her mind was made up or not and whether she was going to rule on it one way or another. Her mind was already made up. She only asked one question. And so then he gets up there, argues the same thing he does yesterday, adding in a couple, this is so bad for the defense. These are rule violations. It's so bad. You guys have multiple Rule 14 violations. So to get up there and bitch and whine with your multitude of Rule 14 violations is so ridiculous to me. Like, come on, man. Like, take several seats down. Like, Bree, you hit it right on the head. That's as close to, Your Honor, this is bullshit, I've ever heard delivered by an attorney. Like, good job, Hank. Good job. Like, I do think they're panicking. I think you're right with that, Jack. That they're trying anything and everything they can at this point to just claw back more time, it seems like, because nothing they're doing when it comes to cross or anything like that is really hitting. You know what I'm saying? Like, we ain't seen nothing yet. Yeah, I'm sure we haven't. The more evidence that comes in, the more guilty Karen is. They can't have that. I agree with you, Jack. I agree. Like, you know what I'm saying? This is just a tactic, a delay, a rile up the mob some more, get them outside sitting in their chairs, like, the whole shebang. Like, yeah, butt dials. It's an entire setup over seconds. And if you heard Alessi in the beginning and I said something, he said, our theory or our whatever is based on this time. Well, if Karen was innocent and didn't do anything wrong, why would your theory be based on the time the Commonwealth gave? It's in the data. It's in the data you were given. It's beginning of trial 1. Her car data, the phone data, all this data, Ian Whiffin's data has been available to you since trial 1. Nothing about it has changed. So why would your theory or story be based on that if Karen was innocent? It would be based on what actually happened and her innocence. No? But again, you're not going to see the cult or the minions pick up on that little piece of it. They just do this. La, 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 I didn't hear that part. Like, I feel like she already made a decision. She's going to let it. She just wanted to know how long it would take them to sort of rebut. I mean, it's very clear. That's why she said to him, like, I only asked one question. This wasn't really a question of was she going to or wasn't she going to allow the information for the Commonwealth. She's going to allow it. It was, how long is it going to take the defense to rebut it? That was her question. So I don't know. I mean, we'll probably see it on the docket when she actually formally puts it. But for me, I can tell that she's already made a decision. You know what I mean? Oh, that's okay, Carol. You can always rewind and then hit 2.5, change the settings on it to 2.5 so they talk a little faster, but like you'll catch up. You know what I mean? That and her being able to like, she's typing talking points during her criminal trial for murder. I mean, the judge really needs to take control of her courtroom, as Joy said earlier, and as we've said a billion times. No, thank you, JMS. I appreciate it. I really, really do. She did create this mess with ARCA. She 100% created this mess. No worries. No worries. Use your PayPal, or it's PayPal, but you don't have to have a PayPal account to do it. You just click on the link and then you can put your credit or debit information in. If you have a PayPal account, you can sign into your PayPal, but that link should work without a PayPal account. Right. It's bad for the defense, So bad. Makes my client look like the murderer that she is. Well, that's also what the evidence does, No, there's not a specific moment. Just kind of have to watch like Alessi be a baby, That's pretty much it. I so badly want to get an interview with Hank, and I'm going to try because I would really like to pick his brain when this is over. I really want to hear his thoughts on a lot of this, especially the mob stuff. Like, what is your thoughts, Mr. Brennan, on all of that? I really want to hear what he has to say. He's like a whiny baby, like a whiny baby. Well, they still haven't figured out, what they're doing with the buffer zone. I don't even think the police officers really know. the judge's order that we read was clear. Nothing changed about the distance of the buffer zone other than they're still not allowed to be on court property or just sitting on the sidewalk in the buffer zone. They can't be wearing FKR shirts. They can't be yelling. They can't be using bullhorns. Like, they cannot do any of that. Like, you can wear your pink shirts and you can, you know, walk through, but you cannot just stand in the buffer zone in front of the courthouse. As that's what the judge's order said. So maybe the judge needs to give some clarification on it. You know, it didn't get repealed. That's the weird thing. Like, the order is, the supplemental order is pretty clear. I think people didn't really know what to do or not to do. And I think the judge needs to make it clearer. Like, she needs to make it clearer. She kind of left some things open-ended by talking about that they couldn't do X, Y, or Z in the buffer zone, but never really said, like, she should have written the whole entire order over is what she should have done. She put a supplemental order into the one that's already in, but she needed to point out what was going to be changed, what wasn't going to be changed, was the distance going to be changed, how much of the distance was going to be changed, where, like, et cetera, and none of that was pointed out. The supplemental order just says the basics of, you can't be screaming and yelling. You can't be on the sidewalks on the courthouse property or on the courthouse property. Like, so, I mean, she didn't make it clear enough for them to enforce or not enforce certain things. So then that's when you get a bunch of confusion. Like, how so though? Like, how, I mean, because obviously I've been here, so I haven't been able to see what's going on there. But how did they figure it out? I know they had like a little powwow this morning, but not like enough to 100% still know what they're doing over there. But again, it's the judge. Like, it's the judge. She's not clear. Like, if you're going to make a supplemental order, reiterate the original order and what has changed and what has not changed. Like, it's the best way to do it so that no one gets confused about what they can do and they can't do. Like, for me, I mean, we're 3 weeks into this trial, 4-ish weeks into this trial, and it doesn't really, in my opinion, change much. The jury's there every day. Like, whether you refine that buffer zone or not, they still can't scream and yell and act a fool. So to me, it doesn't really do shit. Like, you know what I mean? It doesn't help them in any way, in my opinion. Like, are you going to get other people out there acting stupid? Probably now. Probably. I make no mistake that that's probably going to happen. But, I mean, once again, we can blame that on the judge not being clear and having the order be, you know, specific. Like, it's a so-so, Leah. It's like half and half-ish, I'd say. Like, half and half-ish, you know? Yeah, they're basically accusing the prosecution of what, like, they themselves did when it comes to ARCA, which is so funny to me. Like, he does, Ash. He does. They're trying to prevent the Commonwealth expert from refining the seconds and linking up the devices. So, as I explained it a few minutes ago, say you have a phone and a computer, right? Say your computer says 11:37:07. Like, both of these say 11:37 right now, my computer and my phone. But my phone has different clocks in it than my computer does. My computer could be off by 5 seconds, right? So say my computer says right now 11:38 and 5 seconds. But my phone says 11:38 and no seconds. And a crash happens right at that same time. Well, the crash on my phone says it happened at 11:38 with no seconds. And my computer says it happened at 11:38 and 5 seconds. Except it still happened at the exact same time. There's just 2 different clocks in the devices. So that's what they're dealing with. Different clock inside of Karen's car versus a different clock inside of John's phone, etc. Right? So all the Commonwealth witness is doing is narrowing it down from 12:31, you know, as an example, 25 to 12:31:36. You know what I'm saying? Like, And the fact that this one might say 36 in 5 seconds and this one might say 12:36 in no seconds. Like, that's all they're doing. The time is still there. The time she hit him, the time his phone stopped moving forever, all still there. We're talking about seconds, literal seconds. Like, yeah, there was like a quick motion hearing for the sewer turtle this morning for his violation of the restraining order. And that sort of mini trial for that is put on for June 9th. So it was like a really quick thing that happened this morning. But not a shock that he ran into them. They're both deplorable human beings. It's just that simple. Like, so that's what they're bitching and whining about, basically. You know what I mean? They're bitching and whining about nothingness, you know? That's a damn good question, Joan. You would think that they would be, right? Like, Mothers Against Drunk Driving. Like, they're going to show the steps were right before she hit him, in my opinion. That's what they're trying to stop. Well, they're trying to stop anything that shows that their client is very, very guilty. I mean, we know that, No, there's no bigger issue. That's like the little time, like that's what they're whining and complaining about. Like, I agree with you there. I do think that they're very inferior to Hank's level of expertise. But he also has a higher level of expertise when it comes to dealing with both sides, prosecution, the defense attorney. He also has done murder trials. He's dealt with the feds. Like, he's very well seasoned when it comes to a lot of this stuff, where some of these other defense attorneys, I can't say that I've seen any case where Alessi has actually ever been in a trial for murder. I tried to look, I didn't see anything, but like his presentation tells me that he has no idea how a trial works or what needs to be done in front of a jury, what doesn't. It's not the trial. It's like the mini trial for his violation of the restraining order. So like he'll have a trial for the other stuff. This is for the violation of the restraining order on June 9th. You get like a mini trial for it, which is so crazy. The excuse they give, Anna, is the investigation was horrible. That's what they give. That's their excuse. I don't think that she should be found guilty or have this trial because the investigation was bad. So that's reasonable doubt. It's not how reasonable doubt works. People, yeah, I know. Listen, I'm going to make very clear. Most people know this already, but I am very good friends with her. Very good friends. We talk all the time, mostly daily. Sometimes, there's days in between. But I know everything that's going on when it comes to that. I know more probably than anyone on planet Earth other than those two. And I can't wait for the world to see the things that I already know when it comes to him and the lies that he has told and the amount of pain he has put out there to hurt innocent people, including her and her children. I cannot wait, because I would love to see the excuses these people come up with for him. I would love to see them. How do you defend the indefensible? Same way they're doing in this case, I assume, but they're the ones that look like fools when the evidence is punching you in the face. So I don't know. Yeah, 14. Her drinks were too weak. They were too weak, guys. They were too weak. Double shots, shotsies. Her peace and sanity has been taken. Like that sort of peace in your own home where you feel safe has been taken from her for no reason. Like it's not right, the things that he's allowed to do to people, and something has to stop it at some point. Like the crimes just keep getting committed, that's half the problem. Jack sends $14.86 and says TGIF. Thank you, Jack. I appreciate you, my friend. Thank you so, so much. If anybody else wants to make a donation to the channel, we have a multitude of ways to do so before break is over. We'd very much appreciate it. Definitely could use a little bit of help when it comes to the channel. There are, I think Kevin put it very eloquently. There are costs associated with this that people don't even realize before you ever, make a cent. And even when like monetized is great, because I don't know why people tend to donate more when you're monetized. They want to donate on like the YouTube platform. It actually is worse for the creator because YouTube takes like 50 to 60% of those donations. Whereas if you're donating, directly to the person, they don't have to deal with that. Like my PayPal takes a little tiny bit, but not anything like what YouTube does when you're monetized. I'll tell you that much. But Kevin definitely told the story so eloquently about how it sort of went for both me and him. He's talking about himself, but it's the same thing that I went through, which was when we both figured out this was a farce and you stood up to the mob, there are consequences of that. A lot of the consequences are mental and emotional because you're dealing with a lot of harassment and lies and things being said about you that aren't true. People who keep saying that, Kevin doesn't have cancer. Let me just throw this out there. When I sent Kevin the flowers last week, I sent them to the hospital. I called the hospital. I called the hospital first. They sent me to the florist inside of the hospital. And they then had to check, because he was on the cancer unit, okay, if he was allowed to have those flowers or not before I ordered them. So shame on all of those people that sit there and say, Kevin doesn't have cancer just because the sewer turtle said so. This is the problem that we have with people just saying shit and it not being true. Kevin very much has cancer and has had cancer for a long time. He's shown his medical records, for Christ's sake. I wouldn't go that far. My medical is nobody's business. Anybody who knows me personally knows the medical issues that I face and that my daughter faces. Two different things. Obviously, she's her person and I'm my person, right? But two separate medical things that we deal with. Very serious medical issues nonetheless. But who the hell is anybody to try to say someone's pain didn't happen? For all those people who want to call Lindsay a liar and say X, Y, and Z didn't happen to her, you don't get to take the trauma of what she went through and say that didn't happen to you. It did. And then you screw around with all other victims or survivors like myself who have been through something like that. Because then we have to put ourselves in her shoes. What if we were told that our trauma didn't happen, that it never happened because someone called us a liar and went to extreme lengths to try to convince other people, including making shit up and having people write things that are false for him to show people that you're a liar. Things he's been doing long before this case, he did it to people, and he'll continue to do it after, and it won't stop until we, as the public, stand up and say, this is not okay behavior. So many people, even on the Free Karen Read side, say, well, we don't agree with everything he does, or we don't agree with, some of the stuff he does, but there's no but. There's literally no but. If you have the ability to stand up to this mob and say, this is not okay, these behaviors are not okay, the bullying, the harassment, the torment, then like Kevin said, what are you waiting for? Obviously not everybody can do that, right? Like there are some people who just for whatever reason or another just can't. And I've heard it a lot. Some people are afraid for their families, for their, kids and husbands and extended families. And I get it, dude. I get it. And I get it. And that's what people like me are for. But there's very little of us willing to stand up because we know what we're going to deal with. We've already been dealing with it since 2023. We've already been dealing with it. But I will tell you, it is a lot to bear, just a few of us. We need help. We need help. And there's so many people that know that it's wrong and it's bad and it's shitty behavior. We need your bravery, your courage to stand up and say, this is not okay. This is bullying. This is harassment. This is torment. This is, in my book, what you would call terrorism. You're terrorizing people because they simply don't believe in the same thing you do, or they simply are not going to testify to something you think they should to save a woman who is clearly guilty. And anybody who stands up for those people gets tormented and harassed. Well, if there was more of us, if there was a lot more of us, then maybe our lawmakers would start listening. Maybe our police departments would start listening and saying, whoa, whoa, whoa. We got a lot of people here that are saying like, this is not okay. This is not bad. We got so many people that just think it's okay. Well, I've heard from a lot of those people that don't think it's okay, that the behavior isn't okay. Yet here we are. If you have the ability to stand up and say something, do it. Say it. Stand against it. Because we can't do it alone. My grandmother used to say it takes a village. And being young at the time, I really didn't understand what that meant. And sometimes people use it when it comes to raising your kids, and it does take a village. But it takes a village to do anything. Coming together. And something that I wanted to draw on what Kevin said so beautifully, and something that I thought he was saying we need to refine our message, and he's right. Part of that message needs to be, we need to come together as a whole, as one. Because doing it in little spurts and little places, we need to unify and come together to fight this sort of terrorism of bullying and harassment, online bullying, online harassment. It does just as much damage in real life. Some people just think words on a screen. How could it do actual damage? Because there are actual crazy people who live near these people who are willing to do crazy things for their dear online leaders. Okay? Actual things that normal people wouldn't do. And they're being done and have been done since 2023. I lived it. I'm living it. If you have the capacity to stand up and say something, please do. We can't all do it alone. There's only a few of us. I hope that each and every person thinks about, if this was you. What if you were Jen McCabe, Lindsay, Chris Albert, Brian Albert, Colin Albert, any extended family, friends, or just people like Kevin or me or Matt, who have been the ones to sort of be voices of standing up for this, but not with a lot of people. There's only very few of us. And I'm not suggesting you just start a YouTube channel and be that. I'm suggesting we all come together as a whole and say, this is unsafe behavior. This is not okay. Because it's got to draw the attention of all lawmakers to do something about this so this can never happen to anyone ever again. If we just don't do anything, we're going to look back on this and say, what could we have done when it happens again? I'm not willing to allow it to happen again. What I went through alone should never happen to anyone. What I consistently deal with on a daily basis. No one, and I mean no one, deserves to go through that. No one. I don't care who it is. So I don't care if I have to fight alone for the next 20 years to make sure this never happens to someone ever again. I'm going to do what I have to. Been doing volunteer advocacy work for 18 years. This is nothing to me. But I do know that we're stronger together than we are separate. And that's important. Because if we do nothing, there'll be more and more people who are harmed. And I can tell you just from the beginning of this case on, over 100 or more people, 100 or more people whose lives have been altered, destroyed, sullied, their names dragged through the mud, lies and nonsense being associated with who they are when it's all BS. If that was you, would you hope that other people stood up and said something? Would you be begging them to? Would you say, hey guys, you all know that that's not true? Can you help me out here? Because I'll tell you how alone some of these people have felt. And in the very beginning, I did too. Because there's so many people that knew it wasn't true, yet they said nothing. And as a matter of fact, some of those very people helped spread that lie knowing it wasn't true. And that's what every single one of us have been through along the way. It's like we're dealing with some very sick individuals here. I don't know if they just feel like they need to be a part of something. They were looking for friends, if they want a pat on the back from a YouTuber. I don't know what it is, because I can never imagine doing some of the things these people do. It's deplorable and it's disgusting, and nobody should have to go through it. It is a gang mentality. It's bullying. It's adult bullying. No one should have to deal with it. No one should be the person that has to, you know, seem like no one has their back. No one should feel alone. And I will tell you, I have talked to many people who have felt like they were alone in all of this, including, you know, the witnesses, like alone. Like no one cared to stand up and say, I know that to be untrue. Yeah, she's got 2 other boyfriends that don't want to get into this madness and this nonsense, Dougie. And I'm sure you know, as you're talking about it, they don't want to even get involved. They're not even willing to step up, talk to the police. And I get it. I mean, they have families. You know, families and kids and their children don't need to be dragged through the mud. Their spouses don't need to be dragged through the mud. And that's essentially what will happen. But these 2 gentlemen, the poor guys, like they know who Karen is. I don't know if I'd be able to sit back if I was those 2 gentlemen. I totally understand and respect why they do. But me, I couldn't do it. I've talked about it before, but it's not my story to tell. And they're not willing to come forward. And I can't blame them. I can't blame them because they know what comes next if they do. I mean, they could for, like, you know, her state of mind, but I don't blame them for not putting it all out there like that, you know? I don't blame them at all. I just don't. It's a risk. It's a risk, you know? I'm guessing the average age of these people are around 45 to 50, with some being far older out there gleefully. Yeah, it's usually middle-aged, mostly women, but yes, there are men, usually middle-aged, funny enough, but you will see some younger people out there. I think honestly, mostly for clout, to be honest. As you know, as Kevin put it, like those of us who are willing to speak for the truth, like we're losing, we don't gain. You know what I'm saying? There's no gaining here. Every single day, we either deal with harassment or some other crazy thing. Like we're not gaining anything by speaking out. As a matter of fact, we lose. We often lose. Like there are costs associated with streaming. It's not free to do this, right? And so we have to cover those costs before we ever make a penny. Like some of the bigger channels probably do cover their costs. I'm not anywhere near where Kevin's channel is. This is 15,000 or so viewers. I took those breaks, those 3-month and 6 months breaks for my health and my daughter's serious health conditions. So I didn't have that chance to sort of grow that way. But I do the best that I can for you guys to just keep pushing through, because I know that justice needs to happen, and not just for all of the witnesses and all of the people who have been harassed because of this case, but for the O'Keefes. Like they need this justice, right? Lindsay deserves justice. Me and Kevin deserve justice. Anybody that's been harassed by that mob for standing up for the truth deserves justice to be seen through. And that goes through her trial and his. I will be here regardless of if I make a single dollar. If I was smart as a creator, I would have cut out Fridays a long time ago. They're my very slowest day, and they actually hurt me more than they help me when it comes to being a creator. So, I mean, for me, it speaks volumes of the people who are still here speaking up, even though things like streaming the entire trial for 8 hours could hurt our channels more than it helps us. We do what we can to help out, because I have to remember, especially for the volunteer advocacy work I've done, I do it not just because it's the right thing to do and it feels good to help other people, but you do it because you might have been a victim of something before and you know what it feels like. I just happen to actually be a victim in this case. Oh, she was she? shocked that it wasn't Proctor.
So, Mixler, I'm going to ask you that you speak right into your microphone when you answer.
They
if you
can
could,
read,
please.
they can say something in sentencing. I hope they do, Dougie.
All right, Mr.
Fingers
Lally, go
crossed.
right
I hope
ahead.
they do.
Thank you, Your Honor.
Bob Mott is an idiot.
Makes clear.
An idiot. That's not true.
We talked about sort of the physical match or mechanical fit analysis that you did with regard to each of the items individually, correct?
Yes.
And can you explain for the jury the process that you undertook in your physical match analysis between different item numbers?
I love you guys.
So between different items, amongst the questioned ones,
You guys get me through this.
I only compared the pieces that were large enough to have a label on them. Some pieces were quite small. I utilized several benches and divided them up into sections for each item, and individually pulled out all of those pieces. And then I had another bench where I did the actual comparison. I started with all the pieces of the same color and looked to see if any of those had potential edges that could match.
Now, with respect to items 715 and 716, did you do a physical match analysis between those two separate items?
May I look at my notes?
Yes.
Okay. Yes.
And what, if any, conclusions did you come to in relation to your physical match analysis between item 715 and item 716?
Two pieces from item 7-15, F and H, fit mechanically with two pieces from item 7-16, F and G.
And what, if any, conclusion were you able to draw with reference to the physical match between pieces from item 715 and pieces from item 716?
Those four pieces were at one time together as part of a larger unit.
Now, Ms. Valier, what physical match analysis did you do with reference to items 7-6 and 7-11?
So one piece from item 7-6, piece B, fit mechanically with one piece from item 7-11, piece D. So those two pieces were at one time together as a larger unit.
And Ms. Valier, with reference to items 7-8, 7-9, and 7-16, what, if any, conclusions were you able to draw from any physical match analysis you did between pieces from those three items?
So two pieces from item 7-8, pieces C and D, one piece from item 7-9, piece A, and one piece from 7-16, piece E were found to have a mechanical fit. So those pieces were at one time together as a larger unit.
Lastly, for this section, at some point, did you do a physical match analysis for the glass pieces in items 7-12 and 7-14?
Yes.
And what conclusions were you able to draw from your physical match analysis between 7-12 and 7-14?
There was no physical match between the glass pieces from, or parent glass pieces from 7-12 and the glass piece from item 7-14.
Now, Ms. Valier, are you aware that there was an additional analysis that was done with respect to glass pieces and other glass pieces that you didn't examine in your analysis at your lab?
I know that there was other trace work done. I'm not sure exactly what the work was.
Okay. And do you know who performed that additional trace work?
Christina Hanley.
And who is she to you as far as in reference to your work at the lab?
She's my supervisor.
Now, with regard to each of these items individually, they came as labeled in individual bags as we demonstrated on the screen, correct?
Yes.
Okay. And with respect to those bags, did you note any particular date associated on the front of those bags?
That's documented in my photos.
And all I'm asking here is that with respect to each of those bags of items, whether they be 3-1, 7-4, 7-5 or 6 or 8, many of those bags had different dates on them, correct?
Yes.
Okay. And when you received those items in that bag, you essentially remove the items from those individual bags, place them on the table, and examine them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one date that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
Now, if I could turn your attention to item 3-1. Again, for the jury, what is the physical description associated with item 3-1?
Item passenger side taillight, Massachusetts 3GC684.
Now, did you perform a physical match analysis with pieces from item 3-1, 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16?
I compared them, yes.
And what, if any, conclusions did you come to from your analysis, your physical match analysis between item 3-1 and all of the items beginning with the number 7?
There was a physical match with, do you want me to list?
If you could, please.
Okay. So 2 pieces from item 7-5, 4 pieces from item 7-8, 1 piece from item 7-10, 4 pieces from item 7-11, 2 pieces from item 7-12, 2 pieces from item 7-13, 4 pieces from item 7-15, and 4 pieces from item 7-16 were found to fit mechanically with item 3-1.
And what, if any, conclusions were you then able to draw from your physical match analysis between item 3-1 and each of those respective items beginning with the number 7?
Those pieces were once together as part of a larger unit.
May I approach, Your Honor?
Yes.
There, I'm showing you 3 additional photographs. Do you recognize what's depicted in those?
I do.
And what do you recognize those?
This is a comparison between item 3-1 and those pieces from all of the other pieces.
Your Honor, Commonwealth, seek to introduce and admit as the next exhibit A, B, and C.
Is there any objections to any?
No objection, Your Honor. Thank you.
Exhibits 182A and C.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 2096. Ms. Gilman, yes. If you could even zoom in just a little bit more on the item itself. Ms. Villiers, what are we looking at in this photograph?
So those pieces that I labeled from item 7 all of those, they all fit together mechanically into this piece.
And as far as earlier, you were testifying as far as the label maker and the different various pieces that you would label throughout the process of your physical match analysis. Do you see these in this photograph as well?
I do.
And where are they located with reference to the reconstructed piece above?
They're those little white rectangles on the piece.
So what's depicted here is the mechanical fit between items 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16, correct?
Not items 7-8 and 7-14, but the other ones, yes.
And why not those two?
They didn't fit mechanically with the other pieces.
Ms. Gilman, if I could have 2150. And again, if you could just zoom in a little. And Ms. Valier, what are we looking at in this photograph?
So on the right side was that piece that was just shown. And on the left side is item 3-1.
And lastly, Ms. Gilman, if we could have 2151. Again, if you could zoom in on that item just a little. And Ms. Valier, what are we looking at in this photograph?
So that's that right piece on top of the tail light from the previous photo.
And is this the mechanical fit that you were testifying about earlier with reference to item 3-1, the tail light housing, and all of the various pieces that were found in 34 Fairview, starting with the number 7?
Yes.
Thank you. Ms. Gilman, you can take that down. Ms. Valier, lastly, in reference, did you also receive some debris from John O'Keefe's clothing?
Yes.
And Mr. Officer, we can have the lights back on. Thank you very much. And what did you find contained within that debris from John O'Keefe's clothing?
So it was 5 different items. So it was debris collected from, labeled as coming from the clothing. There was mostly debris, some apparent fibers.
Are there any pieces of apparent plastic contained within the debris?
Yes.
Was there dirt contained within the debris?
Yes.
And that debris was labeled as an item 17-18.18. Is that correct?
I believe so.
And what is it that you did with the debris from the gray long sleeve shirt and the orange t-shirt?
So those were all packaged in like glassine folds. And I looked through it and documented it.
When you say you documented it, did you look at it under a microscope?
Yes.
So you did an examination under a microscope, is that correct?
Yes.
And did you measure some of those items contained within the debris?
Yes.
Specifically, did you measure items of apparent clear plastic contained within the debris?
Yes.
And what did you measure those items to be?
The piece of clear apparent plastic was approximately 1/8 inch by 1/16 inch.
And once you had conducted your preliminary analysis of those items, where did those items go?
I did no further examination on this myself. Christina Hanley might have examined some of these further.
Thank you. I have nothing further.
Okay, Ms. Giannetti?
Thank you very much.
Good afternoon.
Good afternoon.
I'd like to first talk fairly briefly about your reconstruction of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1. Am I correct?
Sorry, for which one?
That's the taillight, this 7-3.1. Am I correct?
3-1, I believe.
7-3-1?
The taillight is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yeah. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
How long were you made aware of that?
No.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct? Or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from 1 Meadows Ave in Canton?
No.
Were you ever told about a collision at 1 Meadows Ave in Canton? In any case, you'll agree with me, there was no glass in that taillight at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no glass as part of the taillight, correct?
I mean, it depends on what you call, like, the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass though, correct? Those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've testified to that, correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure of that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Yes.
You never saw that debris inside the clothing, correct?
Correct.
And the pieces of clothing that come in are given evidence numbers when your lab receives them, correct?
Yes.
For instance, the orange t-shirt was given or was named item number 7-17.
Yes.
And the gray long sleeve shirt was item 7-18, correct?
Yes.
And your lab is accredited, correct?
Yes.
There is a complete chain of custody from the moment the clothing was brought to the lab to when the debris was removed from the clothing, ultimately to when you're in court today handling the items, correct?
Yes, our in-lab chain of custody extends from when we receive it to when the submitting agent it is returned to the submitting agency.
Okay. And you have complete confidence that the chain of custody at your lab is effective at making sure that the evidence does not get lost or mixed up or contaminated, right?
I mean, chain of custody is meant to track where a piece of evidence is. The evidence unit also does inventories and audits to make sure that things are where they're supposed to be.
And you have confidence in your lab's chain of custody policies and procedures, correct?
Yes.
But you'll agree that your lab cannot control who handled the clothing before it arrived at your lab, correct?
Yes.
There are times in which crime scene technicians or criminalists from your lab actually participate in the search for evidence at a crime scene, do they not?
Some of the people at the lab are crime scene responders, yes.
There are times when they actually take custody of evidence, again, I'm talking about people from your lab, professionals, they take custody right from the crime scene and transport that evidence to your lab, correct?
Yes.
In those circumstances, your lab would have a complete chain of custody from discovery to seizure to testing or whatever comparison you're doing until you release the items, correct?
Yes, but the electronic chain of custody doesn't start until that item is entered into our LIMS system at the lab.
Right, but when it's entered in, it would be entered in as having been seized by somebody from your lab, correct? In the hypothetical that I'm giving you.
Yeah, there's an evidence submission form that says that this crime scene responder submitted it to the laboratory.
There are other cases, however, when the evidence is brought to your lab by the police, correct?
Yes.
Local departments have access to your lab?
For evidence drop-off, yes.
The state police have access to your lab for evidence drop-off?
Yes.
And in this case, it was not a criminalist or other professional from your lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes. Okay. Do you have that with you now, Ms.
I do.
All right, go ahead, Mr. Manning.
Having reviewed your reports, can you testify to the jury about who it was that brought this evidence into the lab?
So you can tell us.
Okay. So submission 7, all the items that are 7- was submitted by Trooper Michael Proctor.
Were you aware of the date of the incident that gave rise to this case?
Yes.
And what was that date?
January 29th, 2022.
Were you aware that the clothing that you received was seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought to your lab?
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me that was about 6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of 2022, correct?
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained.
Do you know where Michael Proctor stored this clothing during that 6-week period?
No.
Do you know how often he was alone with access to the clothing during that 6-week period? Do you know if he had access to pieces of red or clear taillight during that 6-week period?
Objection, strike out.
Sustained. Move on, Mr. Manning.
You were not present when the clothing was seized, correct?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Mayor. Move on, please.
One last question. You cannot vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
I cannot.
Doesn't what?
Any further, Mr. Lally, or are you all set? Okay. I'm not curbing it.
Mr. Lear, there is a separate evidence unit contained within the Massachusetts State Police Crime Laboratory, correct?
Correct.
And fair to say you have absolutely nothing to do with that, correct?
I'm not a part of that unit.
And so your responsibility as far as chain of custody is concerned is from when you retrieve the item during your analysis and then when you return the item to the evidence unit, correct?
Correct.
And from that analysis that you performed, you found that there were 10 different items, starting with the number 7, that were a mechanical fit to 3-1, the taillight housing from the defendant's vehicle, correct?
If it's 10 items, I don't have, I can count them.
Okay. As far as all those items beginning with 7 that you went through or elucidated on your direct examination, each of those were a mechanical fit to each other and then to the taillight housing in 3-1.
The pieces that were previously stated, yes.
Nothing further.
All right. Mr. Leahy, you are all set.
So who's next? Who do we think the Commonwealth has next? Give me the ring guy. Give me the ring guy.
All right, so jurors, that is it for today. I'm
What?
told when I spoke with counsel earlier that we are still on track.
You're kidding.
I have to tell you those same cautions. Please do not
What?
discuss this case with anyone. Don't do any independent research.
she
or
serious right
investigation
now?
into This case. If you happen to see, hear, or read anything
I
about
can't.
this case,
I
please disregard it and let us know. Be extra careful with your social media
I'm gonna
use.
lose my mind.
So I just want to remind you, next week, Thursday is a half day and Friday is a day off.
What?
So we'll see you on Monday.
Why? For what reason?
Oh my God.
This is absurdity. I don't even know what to say. You can't possibly be on track. You lose an entire day this week. You told them it was a full day every day. We stop at 12:26. That's it? No other witnesses? What? I'm sorry, what?
Okay.
This is absurd.
So before we recess, I appreciate that council provided me with the information. Mr. Leslie, I got the 2 reports that you had that were incorporated in what the Commonwealth had given me a few minutes before, but I appreciate that.
This will never
As
end.
pointed out here, we've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information.
Shocker.
And I don't find
called
that
it.
there's delayed disclosure. Of course, all of this is ample game for cross-examination. Certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination. And I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher,
very obvious,
as my understanding, the request yesterday was for, and it's been a request, I think, a few days, We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not,
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right. So I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All rise for the court, please.
That's it. I fucking can't. I can't. I literally can't. Karen's day off definitely threw this off, but there's no reason that they couldn't have planned to scoot some of it up. 12/29. I've never seen. And then you're going to tell me that Friday of next week is a day off. Thursday of next week is a half day. Like, I'm sorry. What the actual what? This is insanity. If you ask me, absolute insanity. This judge really needs to get her crap together, in my opinion. This is nutty. I mean, this was definitely a decision I already saw coming, especially when she said, Mr. Alassi, I only asked you one question. That was very clear how she was going to rule. So I could give myself credit and say I knew again. Shocker. I do want to know what the batting average of some of these law tubers are. Like, do they guess things and get them wrong all the time? They must, right? I mean, and here's the problem that I have with that is they know damn well, just as well as I do, what's going to happen or isn't going to happen or could happen. So they can weigh the arguments just like I can, except there's just a little difference between me and them. And that's, they hold a bar card as an attorney. I'm not an attorney. I probably have more knowledge than most of them when it comes to the law, but I myself am not an attorney. Yet somehow, some way, I can figure it out pretty easily on what's going to happen and what isn't going to happen. That's what really burns my behind. Is, hey, look, it's me. Hey, look, it's showing me on the screen. That's hilarious. Hold on, let me remove that just because it's going to show multiple of us. Move that down a little. Amazing to me. Amazing. Freaking amazing. Absolutely amazing. I'd be pissed. Would you not be mad if you're the jury? Like, would you not be mad? Like, if I'm the jury, I am very unhappy right now. I am pissed the hell off. I am pissed the hell off if I'm the jury. No doubt. I'm just pissed the hell off. Like, I do think she screwed the schedule by calling in sick, but at the same time, they could have moved things forward a little. Like, for them to shut it down, like, stop it right now, 12 something. Oh, we're done for the day, everyone. Like, oh, but remember, Friday of next week's an entire day off, and Thursday of next week is just a half day. A half day before an entire day off? For what? I don't understand. Of course, Francesca, of course. I don't understand. I'm really like, what in the actual F and F right now? And that's another thing. That has just got to be a bold-faced lie. You can't keep saying you're ahead of schedule. You miss an entire day. Keep doing like time off. You cannot possibly still be on schedule. There's just no chance. Like, you have to be behind at this stage in the game. You have to be. You just have to be. Like, I always think there's something going on there, Dougie. There's always something that I feel like they're scheming or doing over there. Like, I mean, we can guess by like the amount of trolling that side does, or like the amount of harassment I get per day. I can usually gauge whether something's going to happen or something is happening or they're planning something. Like something weird is going on over there, and I just haven't been able to quite put my finger on what it is yet. But I will. Like, there is a guard on Karen Reed's dad because he can't control himself and his outbursts, staring down the jury, winking at the jury, making comments to the attorneys. He can't control himself, which is he could control himself in the first trial. So what does that tell you? He didn't have this issue in the first trial, which means he thought the first trial was going well, and he doesn't think this one's going so well, right? That's what I would gauge at this point. Any of those law troopers telling you this is going great for the defense are lying to you, and you should just disregard them saying that at this point, because they damn well know this is not going well for the defense. The first thing Hank did this morning was play the clip of Karen saying she pulled that piece of glass out of John's nose. Well, Carrie's the one that uncovered his face. So how did she pull a piece of glass out of his nose? And he had no signs of life when they found him at 6 a.m. So she pulled a piece of glass from his nose and he gushed blood. I mean, that wouldn't, not to sound morbid, but dead people don't gush blood. So I call BS. But what that tells the jury is one of two things. Karen lied and made that up. She went back at some point before Carrie and her got there. Actually not an or, but an and if there's glass in his nose, that means there's very well glass that could have scratched him up here if there's a scratch here, and she pulled the glass from his nose. So she kind of did 2 or 3 things in that one statement to the jury. You know what I'm saying? Like, yeah, that also tells me that they're not confident that there is plants on that jury if Bill Reed can't control himself. So, you know, that's part of the, you can gauge a lot from what they do, what they say, what they don't say, what they do, what they don't do. You know what I mean? I do believe that as well. A lot of us do, because he is so personally involved when he does his crosses that he is literally emotionally, like, it's a personal, emotional response, not a lawyer response to a witness on the stand, but a very personal response, which leads me to believe there is something going on there that shouldn't be going on there. And if I'm Alan Jackson's wife, who happens to be a DA in California nonetheless, okay, then I'm no happy camper right now. He'd be lucky to come home to his things this weekend on the side of the road. Just saying. Like, I do think that the jury thus far has not shown Karen Reed's side what they want to see from a jury. Jury got scolded today about making noises or saying things under their breath or making faces. But how can you not? If something shocking happens, it's like almost like automatic. You're going to be like, what? Or if you see something like Alessi needed to show John's stomach content, what his stomach looked like outside of his body, nonetheless. You made a juror sick, and I called that as well. Did I or did I not? Did I not say that's going to make a juror sick? That is a really risky move if you are a defense attorney to make a juror sick and piss off the jury, especially when there was not a reason to actually show it. There was no reason on planet Earth he had to show that at all. Shock value? I don't think that's going to work in this case. Plus, the people repeating that Bob Alessi he's so smart and he's doing so great. And take another good look at what you trust coming out of that person's mouth. I don't know any actual attorneys that think that Bob Alessi is doing great right now, except for the ones on YouTube that are trying to draw FKR people in. That's the only people I know of that are claiming that Bob Alessi did some magical great job. Like, dude, even I'm burned out, you know? Like even I'm burned out. So a half day is not bad for me. For me, I'm like, okay, it's a half day. I can get some other stuff done I needed to do on a Friday, whatever. Like, but it pushes the trial back more, right? Like now we're waiting longer for it to be over and for justice to happen. And they're not able to do this third party, right? They're going with more of a Bowden. But I am noticing that there's a pattern in blaming the dead chief. Let's blame dead Chief Berkowitz, who can't defend himself. That's low. Chief Berkowitz had nothing to do with anything. So to drag Chief Berkowitz, poor Chief Berkowitz into this, like the man's no longer alive, okay? You want to keep mentioning Chief Berkowitz as if he's the devil. Like that's just absurdity. Like nonsensical, okay? Like Chief Berkowitz had nothing to do with anything other than driving by, finding pieces of taillight. It's his town. He was the chief. It's his duty, right? Darvo is all they have, right? Blaming the victim, spinning it around on the victim. It is literally what FKR and the Sewer Turtles viewers do the best. Is just cause havoc in people's lives and point the finger at everybody else except the person that it belongs pointed at. Yeah, blaming a dead man and a dog. Like, complete foolishness. Utter foolishness, if you ask me. Just utter foolishness. Like, there's low and then there's real low. Like, real low. I also think there's some confusion when it happens to be about the buffer zone. There's quite a bit of confusion. Like, that's never good when there's confusion about something. You know, like the judge is not clear about certain things, and that's her own fault. Oh, yeah, depths of hell low. You can say that again. 100%. 100% you can say that again. It really burns me. I'll tell you that much. It pisses me off. It pisses me off. I don't like it. Well, we have been here for 4 hours, so it's been a while. 4 hours is a long time. So I will try to hop off, try to get some other things done that I need to do. My back is killing me anyway, so maybe it's good that I get a break for my back and all of my body parts that are in chronic pain. I'll tell you that much. Oh God, I don't even think we can count that many at this point. It's how many times they've said Proctor? Whew, a lot of times. A lot. If you'd like to make a last minute donation to the channel before I go, Freak has all the information in the chat. Obviously, we have a link for people who can do it. Just credit or debit. You don't have to worry about having a payment app. It is a PayPal link, but you don't have to have PayPal to donate, just a credit or a debit card. And then we have Venmo, Cash App, PayPal, Revolut, and then we have a link for you Apple Pay. People will give me a mental health break too. Yes, abso-freaking-lutely. One that I could use just like everyone else. That's for damn sure. It's definitely always helpful to donate to the channel. Fridays are actually our slowest day, funny enough. I don't know why. We will have a Sunday show this weekend. We did not have one last weekend because it was Mother's Day. And I was going to do a Saturday one, but then I ended up in the hospital from Friday to Saturday. So that didn't happen either. So we will have a Sunday morning show this week. Probably around 10 or 11, as I usually do. Of course, I will let you guys know on Discord what about time we'll do it Sunday. I'm thinking about possibly doing a nighttime Saturday show, depending on if people want to do. Let's put it that way. If people want to do a nighttime Saturday show, because I do have quite a few viewers that are on the replay crew that don't usually get to interact with the chat. So I feel like I got to try to attempt to bring them some live chat. You know what I mean? Some live, times that they can, which is why I do the Sunday show, but that's not always feasible for people either. So maybe we'll try to do a shorter 2-hour Saturday night show. But again, I know there's other people that do Saturday nights. So yeah, we talked about that, Monarch, the break. And that was because I called it. Did I not call it? He made someone sick. He made someone sick with chilling the stomach. We just talked about that. Like, what the hell? Like, I called it though. I knew it was going to happen. It's very risky. It's very, very risky. Very risky. It was not scheduled to be a half day. This was scheduled to be a full week, full days, JMS. Full week, she said. Full week. So what happened in the meantime? What happened in the meantime? I don't know. Like, I don't know. You know what I mean? Like, was she? Shut up. That's hilarious. You know, I have to imagine that if they're in that much of delusion that they actually believe that like Alessi's doing wonderful and great, like that they come back down to reality and realize that he's not doing so great. You know what I'm saying? Like, not doing so great. But who knows? Who freaking knows? But listen, I love your stinking faces. You guys let me know if Saturday night is a good time to do. I was just going to go call you, Lynn. If Saturday night's a good time to do one. If we don't have enough interest, I'll stick with just Sunday. If there's enough interest for a Saturday, I'll try to figure out a time because I know there's other people you guys watch on Saturday nights. So I don't want to step on anybody's toes that already do Saturday nights. So it's really just up to you guys. If there's interest in a Saturday night, I will totally do a Saturday night for a shorter, maybe 2-hour show for people who aren't usually able to be here during the day. Yeah, maybe I could do like a 6-ish one, like a 6 o'clock, 6-ish, 7-ish time here might be a good time instead of like 9. I also have to remember about, the West Coast, which is what I keep in mind, is that they're 3 hours difference. So I guess we'll see. No, that's it. They're done for the day. They're not discussing anything. They just done. See you later. If you guys make a donation to the show when I'm not live, I will just read it on the next one. So if you make one when I'm not live today, after I get off, then I will read it tomorrow night. We do a tomorrow night run, Sunday morning. If we do a Sunday morning one, it's always well appreciated. And what the hell? Well thanked. I have my windows open because it's nice out. Because actually Fridays are the show's slowest days for whatever reason. I have no idea why. It just is. It just is. So it's definitely always super helpful. I appreciate you guys. I love your faces. If there's anything you guys need in the meantime, you all know how to get in touch with me one way or another, whether it's text message, phone call, Discord, email, twistedtragedies3@gmail. You all know how to get in touch with me. So if you need me, please reach out. Don't not reach out. Okay. We can always help if there's something going on, or maybe you just want to get something off your chest. Maybe you just want to chat. Maybe you are just having one of the days that I'm having today or any day. You know what I mean? Like maybe you're having a crap day and you just need to scream or cry or talk about something else to completely get your mind off of it. You know what I'm saying? Like one or the other. Like join our Discord. You can always get in touch with anyone there at any time. And there's always a community of people to help lift you up because nobody should suffer in silence alone, even if it's just having a bad day. It's sometimes you just need somebody to tell you like, it's going to be okay. I'm going to go. I love your faces. I'm going to go call my friend. Someone needs me. So I'm outie. See you guys later. Bye.